well spent. So I think that's a good recommendation, the task force.
Oh, that's great. Thank you for sharing that. Thank you for that.
Yeah, I didn't want to interrupt the flow of the witnesses, but when it gets to the point where we make recommendations, I really like that idea has served our history really well.
Excuse me. I'd like to remind the members that we're still live and we're recording.
Okay, thank you.
Okay. Mm-hmm. So it is 1:03, and the California Reparations Task Force has now reconvened. We'll go on to our next item on the agenda, which is subpoena and information request, review, discussion, and possible action item. We will have 45 minutes, so up to 1:45 p.m. for this particular agenda item.
Madam Chair?
Yes, Parliamentarian Johnson?
I just wanted to remind you of having to take the roll in reestablishing the quorum.
Oh, thank you so much, Parliamentarian Johnson. My apologies to the task force and members of the public. I will now call on Parliamentarian Johnson so that we can establish a quorum. Thank you.
Chair Moore?
Present.
Vice Chair Brown? Member Bradford?
Here.
Member Grills?
Present.
Member Grills, thank you. Member Holder?
Present.
Member Jones Sawyer?
Present.
Member Scott Lewis?
Present.
Member Tamaki?
Present.
Member Montgomery Stepp?
Present.
The task force consists of 9 members. 5 members are necessary to have a quorum. There are 8 members present. Madam Chair, a quorum has been reestablished.
Thank you so much, Parliamentarian Johnson. So it is now 1:04, and the California Reparations Task Force has officially reconvened. So we will now go to our next agenda item, which is subpoena and information request, review, discussion, and possible action item. And we will have until 1:45 roughly to finish this part of the agenda.
Good, Madam Chair. Look at my present.
Vice Chair Brown, you are recognized. Mm-hmm.
Yeah, I said they record me as being present because my phone was not on.
I believe so, Parliamentarian Johnson.
Yes, I have made that correction to the record.
Thank you, Parliamentarian Johnson, and thank you, Vice Chair Brown. So I believe we'll be turning to members Holder and Tamaki.
Yeah.
Thank you.
Thanks, Chair Moore. I can get us started on this. This is a little boring and formalistic after all of the, star power we had this morning, but we'll do what we can. So, at our last meeting, the November meeting, the task force empowered Member Tamaki and myself to do a little bit of investigation and reconnaissance around task force's subpoena power and to start to investigate items that we might want to subpoena or demand from government entities regarding the work that we're doing. We put together just a little slide presentation just to roll things along as we give you an idea of the work that we've done so far and the work that we anticipate doing. Yeah, thanks. So as this first slide shows, under the legislation, AB 3121, we as a task force are empowered to request the production of books, records, correspondence, memoranda, papers, and documents. We have the power to seek an order from the Superior Court compelling testimony or compliance with a subpoena. And any task force subcommittee or individual member may, if authorized by the task force, move forward and deploy these investigatory tools if we deem it necessary to get this information. So we can go to the next slide. And just for more information about what are the entities that we could potentially use our subpoena power with, who are the entities that we can demand documents from or compel to get documents. So those are, state agencies essentially, and under the legislation, state agencies are required to cooperate with our requests and demands for documents that could assist us in this work that we're doing to analyze the case for reparations. The investigatory tools include potentially subpoenas, right, where we're actually writing a legal subpoena telling a state agency that these are the documents that we need to further our work. They could also include almost something more like a request for, like an interrogatory, like a question, like in the form of a survey, where we say to a state agency or a municipality, etc., look, these are the areas that we are exploring as a task force, and some questions have come up about your control and access to documents that we think would be helpful for us, right? So we can do that in the form of a survey, and a written survey where we ask them certain questions and either ask for documents in response to the survey or ask for a narrative response. So we can go to the next slide. And just to talk a little bit about, we know what the investigatory tools are, the subpoena and the potential surveys and interrogatory questions. And really, what is the utility of this, right? Of going to a state agency and asking them for documents or for this type of information in narrative form? Well, given the work that the task force is doing to prepare this extensive report, we could use our power in the form of surveys or subpoenas to get states to answer questions and give us information that we think might be missing from our reports, or that we need to add information that we feel like we need to make our report or an issue in our report more robust, right? So if there's some gaps that we need to fill out in our report, perhaps some of these state entities might have documents or information that could fill in those gaps or make the report more robust. We also think that this tool, these investigatory tools, may be very useful in increasing public knowledge about what's out there. What does the state have in its possession and control regarding discrimination, right? And so that just expands the public knowledge about, what representative government, what kind of information their representative government holds on this. And we have put together, this task force is very interested in having a strong community engagement process, right? And we think that using these tools could potentially be leveraged to increase our community engagement, right? By drawing the attention of the media, if we decide to use these investigatory tools to investigate something that, that is very interesting to the public, that could draw media attention, which in turn could enhance our community engagement and bring more people into this process. So those are some of the reasons why it may be useful to deploy these tools other than just to get the documents. So we do want to talk to you. This is just sort of an overview of what we've compiled in terms of information that we've gotten from the DOJ about the power that we have, and just the Member Tamaki and I, our thought process around the utility of this power. We've also come to realize that there are many challenges to using these investigatory tools, and Member Tamaki is going to talk a little bit about those potential challenges.
Yeah, I think the key in this thing is that the use of these investigatory tools have potential and theoretically could be very useful, but the practical challenges candidly may outweigh, whether any of this is deployed. Let me sort of give you an overview of that. The Department of Justice's retained experts and historians and the lawyers have already compiled and synthesized voluminous amounts of material documenting the lingering effects of the institution of slavery, Jim Crow, de jure de facto segregation, and other manifestations of systemic racism. We've got literally 500 pages merely of outlines. And if you looked at the bibliographies, they're all heavily sourced. So I think it's a fair question to ask whether our exercise of any of our investigatory tools would significantly add value to the already existing voluminous data that we've already compiled. And if the life of the task force was not, going to sunset in June of 2023, but could go on for, much longer, then it might make sense. But we're in a very aggressive and short, time frame. So part 1 of the report is due June 1 of 2022. Part 2 is due June 23rd, 2023. And then the task force expires. So because of these time deadlines, it is also possible that a target, and Lisa mentioned the state agencies being a target, or government entities, but also could be private parties. As so often happens in litigation, for those who are familiar with it, you often don't get cooperation. So the parties might seek to delay or refuse to production and information, essentially to run out the clock. Now, assuming the task force can quickly identify appropriate subject matter, and the subject matter is vast. It's 400 years of oppression plus matters particular to California. And if we identify subject matter and a target susceptible to our use of investigatory powers, which we think might produce useful information, the process probably from the start that the survey or the subpoena is issued, at best is 3 months, and it's probably 6 months after that before we get responses. Now, if the target refuses resists production, or is non-responsive or evasive, or engages in such tactics as producing, let's say, thousands of pages of documents that are non-responsive, in which case we would have to, painstakingly, laboriously sort through them, the process could take considerably longer, and especially if the Department of Justice has to go through with a subpoena process. So this is pretty typical in litigation, but it doesn't work well, given the limited time frame of the task force. So given these challenges, what we're searching for, and that is, Lisa and I've been, is low-hanging fruit, so to speak, through which the exercise of investigatory power could be done relatively quickly and efficiently, and which would provide, useful information. But identifying this narrow area of inquiry has not been easy. I mean, we've been in contact with multiple sources, both in government and private parties. And we've in particular focused in on researchers who have already done, lots of work in these areas to basically inquire, is there anything that we might use these investigatory tools to augment what they're already doing to further their effort, and then in turn would also redound to the benefit of the task. So in short, I mean, this sort of describes the problem. I mean, the legislation does give us this authority, but the question is whether it's worth using it. And so the jury's still out on that. We're still evaluating it. Turn it back over to Lisa.
Yeah, I tend to be an eternal optimist, and I feel like there is information out there that would have a lot of that would be beneficial, obviously, to the public and would have utility for us in terms of making our recommendations. But because of the scope of our work, it's hard to find what is just the right subject matter area to really explore and really use all of these extra tools to drill down on. So that's the challenge. And just to update you guys on what we've been doing for the last month, Don Tamaki, Member Tamaki and myself, is we have engaged in an exploratory process where we have spoken to subject matter experts in criminal justice, in housing, around issues of redlining, restrictive covenants, sundown towns, family separation. We've gone out and we've spoken to researchers, activists, subject matter experts in these areas to find out what work they are doing, what information are they missing in the work that they're doing, like what would be really helpful, what type of information they could get through a subpoena that would be helpful to them in doing that work, and would also be helpful to us in putting together our report. So we have, Member Tamaki and I have reached out to many subject matter experts to move this process forward. And we would actually like a little bit more time to continue that exploratory process and then come back to the task force with something more definitive in our next meeting. So that leads us to our ask and the motion that we would like to put forward. And obviously we can have discussion, but we do want to show you the proposed motion to sort of facilitate that discussion and move the process forward so that we can finalize what power the task force is willing to give us to continue our exploration and finally make a definitive decision ultimately about whether or not we want to use these tools and where we will direct the tools.
Yeah. So the print on this is small, so bear with me. I'm going to go through the motion and summarize it where it makes sense. So the first paragraph is, whereas in our October meeting, the task force authorized Member Holder and myself to evaluate whether the exercise of these investigatory tools is practical and in fact would benefit the work of the task force and further the public's knowledge and engagement. And whereas we've made some progress, I'll call ourselves the subpoena advisory members. We've gotten some information, and some likely areas look better than others. We need additional time to evaluate this. And whereas if there's a practical, efficient, and useful way to exercise these investigatory tools, and again, understanding the resources and time available both for task force members as well as the DOJ that is plowing through and putting forward this report and organizing the community engagement meetings and so on, that in all of this, time is of the essence, as we do all of these things at once. And given the process and the time it would take to issue the subpoena or the other tools, gather responses, perhaps compel production by court action, we needed to come up with, a strategic plan as to how these tools might be deployed. So therefore, we're proposing the following motion, which charges Lisa Holder and myself to continue to do the following. And that is continue as a, I'll call it the Subpoena Advisory Committee, to explore and evaluate the process to determine whether there is a practical and efficient and useful means to deploy the investigatory tools. And if we find that there is such a practical, efficient, and useful means to deploy these tools, that advisory member Holder be authorized to instruct the DOJ to proceed. And although we certainly would report back to the task force, because I think time is of the essence, just given the time that it would take to get meaningful responses, to review them, go through them, evaluate whether we have to compel production. This motion would authorize Lisa Holder to be able to authorize the Department of Justice to proceed. And the AB 3121 permits the task force to authorize a single member to take the action of the task force. And so the motion basically encapsulates that if we find such a efficient, useful exercise of these investigatory tools, that member Holder is authorized to instruct the DOJ to proceed. I think with that, we can open it up for discussion.
You need a second for the motion?
Oh, yes, please.
I second.
It's been properly moved and seconded that Member Tamaki and Member Holder will continue their exploration and evaluate process to determine whether there is a practical, efficient, and useful means to deploy the investigatory tools. And if advisory members determine that there is such a practical, efficient, and useful means to exercise the investigatory tools, advisory member Holder may instruct the DOJ to deploy these tools. And now we can move to discussion. Are there any comments or questions to members Holder and Tamaki related to this proposed motion? Member Jones Sawyer, you're recognized.
So I want to be as helpful as possible. Probably the only person on this committee who was a public servant who was served a subpoena to produce documents in a court proceeding. It really comes down for the department. Well, maybe there's a question of previously, have we received any pushback from departments not wanting to give us information? That's one. Two, hopefully in your research, when you say practical and efficient, you look at obviously funding, resources, and timing to be able to get this information. You'd have to get, you literally would have to get folk or department heads, if you're looking for information out of the department, to have that section head or that entity or that department to drop everything that they're doing in their priorities right now, today, that maybe the governor wants, that the legislature wants, to specifically do this. And that comes into timing, then deploying people within the department to do it, and making sure, which is probably the most important, if it requires additional funding, that that money will be authorized. Where it may be a case where it's not a case of they don't want to do it or provide the information. But if you have an honest conversation about how to get this done, if we can get everybody, all the ducks lined up, you can get it done. But if we're fighting over money, resources, and timing, it could become a fiasco. So as part of your strategic plan, hopefully you can devise something where you can get everybody working on the same page. So my first question is, do you anticipate departments, or do you feel that they would be reluctant? I can see private sector. Oh my God, I can see it, because they're afraid we're going to sue the heck out of them. I can see the private sector running out the clock every day in every way. But the public sector, with a little push from the governor's office, who is their boss, the executor, we shouldn't, as a body of the government, we shouldn't have any problems getting information as long as it's authorized and everybody's on board.
That you've said, Member Jones Sawyer, is we've talked about and trying to be mindful of. I mean, exactly right. That some of the agencies are already going to be extremely busy. And for example, if we put out a survey to cities, and leaders and department heads are already dealing with COVID and everything else, this could get lumped on to all of their other responsibilities. So for example, if we ask the Department of Real Estate which was established in 1917 or 1918, to give us an overview of every complaint, made by African Americans about restrictive covenants or redlining or whatever.
Appraisals.
The hunt that it would take to start uncovering those documents, you can imagine that it might be extremely difficult. And so I guess the first question is, can we narrow this down so the work from the respondent won't be overwhelming, or such that they either don't respond or they just copy thousands of pieces of paper that we all have to sort through? And the other piece of it is, from a private entity, I totally agree with you. They could take a very defensive posture, and then we're in a big discovery fight as if we were in litigation. So I think these investigatory tools, to the extent that they are to be deployed, have to be deployed with care and under consultation with the Department of Justice, particularly if there are state agencies, but also any government entity. So that was kind of the thing that stymied us. I mean, you could send out bunches of subpoenas, but whether you're going to get anywhere and whether that's a useful way to use people's time, including the Department of Justice and the task force, is another question. So we spent the last month literally sort of poring over this, and Lisa and I, and it just concluded that for the exact reasons you stated, we really need needed more time. We need to explore this carefully and then work with the DOJ on crafting something that might make sense, or not use it at all. That's the other possibility.
I was just saying, I'm just thinking of just what we learned today from the city of Santa Monica, which has put itself up as the liberal bastion of California, and the racist acts that they did. I don't think the city of Santa Monica is willing to let that information get out, even though this is a public forum. That's got, just what was said today has got to be unbelievably embarrassing to the residents, to the elected officials, to the founding fathers of Santa Monica, and the people who are running that city now. And then for us to dredge it up again and then make claims to parts of Santa Monica could be, can you see how difficult it would be to try to get them to come along?
It would be. although Member Holder and I have talked about the political impact of a non-response. In other words, if a reasonable response was made about such thing and they say they stonewall it, that in itself may be a newsworthy story. So that would also be taken into account. But my main message back is I think you're absolutely right. We need to be mindful and careful and thoughtful about how we use these tools. And we don't want to, I mean, the Department of Justice, for example, just on the report itself, has had a team of 10 people working on it. And so, and under a huge time frame, time pressure. And it's a report that's already exceedingly comprehensive. Maybe it'll be an authority that people across the country can rely upon. I mean, all the expert treatises are to be found in one place. So what can we do that might be meaningful to augment that? You know, might not be much. So I think we just have to be realistic. We didn't want to raise the expectations of the public or the task force that exercising subpoena power was going to unearth something we don't already know. So I think that's the lens by which we're looking at this.
Member Montgomery Step, you're recognized.
Thank you, Chair. Really do appreciate the conversation and the presentation. I just have a question about the length of the subpoena authority with the sunsetting of the task force. So if we were to put a subpoena out there as the reparations task force, and then we are dissolved due to the legislation, would that subpoena still carry its authority? And I do think that there could still be good information out there that can still be a part of the record, because once we finish our work, then it's gonna go to the next stages. But I'm just wondering if that document would still have that authority.
I mean, I'll give you my uninformed legal thing. Normally, when the party dissolves, if the party requesting the discovery, the information is no longer there, then it becomes a moot. But I defer to any input that Michael Newman of the Department of Justice might offer up, or Lisa. But it's generally parties that get into this back and forth on discovery, and the party is the task force, and literally we are out of business as of June 23rd, 2023. So I think we're under a severe time frame. Maybe Michael, you can offer, another opinion, but.
If I may, yes, I think we'd have to research it given the statutory period of the task force. But I think that's always one of those issues where when subpoenas are issued by a short term or a defined term entity, people try to run out the clock. And so I think that is something that we would need to research and then come back to the task force with a more definitive answer on. But I think you're spot on, Don, Member Tamaki.
But one thing I will say to Member Montgomery Step, because I appreciate the question and something we've grappled with, and that's why we presented to you some of the challenges, because it's really a time constraint, right? When I do lawsuits, these civil rights lawsuits, they go on for 4 years. So no one can run out the clock on that subpoena. But here we have a very short time period. And practically speaking, it's even less so, because we're going to have a 2-part report. One of those reports is going to be rolled out in a few months, right? And the next report is a few months after. So we really have a short time period that we're dealing with. But I think one of the utilities of this exercise that we're going through and exploring the subpoena power is that we can actually figure out whether 2 years is actually sufficient for a body like ours to exercise the authority, right, within their purview. And for the sake of posterity, because I believe there's going to be future commissions like this, there could potentially be a federal commission like this. I think it's helpful for us to exercise this process and figure out, is 2 years really enough for a body like this? And then maybe put out sort of like an advisory or a declaratory statement about our experience. So, you know, even if it turns out not to be fruitful in the obvious way, it could be fruitful in terms of our knowledge going forward with these types of commissions.
Yeah, I completely agree. And even, you know, how we can use this power strategically is something you have to think about too. So thank you very much.
Are there any other questions from members of the task force related to this discussion?
I'd like to add one comment.
Yes, comments as well. Member Scott Lewis, you're recognized.
Thank you. So when we had Damian Goodman yesterday giving testimony about the experiences of his organization, and in spite of his organization providing, say, the highest bid for property still being denied, I think, you know, something along the lines of the subpoena might allow for us to understand a bit more about how some of these opaque processes continue to produce contemporary disparities. And so I think, you know, that might be a really good example of how we might actually go back to our witnesses to kind of think about what things they are trying to undertake, and seeing how we might be able to use our powers in relationship, in partnership with their efforts, to kind of advance, you know, some of the exploratory aspirations that we have. So I just think yesterday, you know, Goodman's example was really striking. And I think, you know, something like that does deserve further examination. And I think if we do, you know, decide to support that kind of work, then it ends up helping us to create the kind of longer narrative of how these injuries keep showing up and evolving in these ways. So we're thinking about redlining, we're thinking about racial covenants, right, as this historical kind of, you know, property and housing disenfranchisement. But we're seeing with Goodman's testimony yesterday how these processes are evolving in real time. And we need to try and hopefully get ahead of some of these things and not always be thinking and arguing around them retrospectively.
Member Scott Lewis, and we, for example, have conferred with Dr. Michael Stoll, who testified, and also Professor Helen Kang and a few others. And we're seeking out other people who not only testify, but also who are experts, but we don't have to kind of, you know, explore areas that people have already spent a career, you know, studying, to see if there's something, you know, we could use that it would be useful and it's narrow enough and efficient enough. And so that you're totally spot on in terms of your thinking on that, I think.
No, yeah, I absolutely agree with Member Scott Lewis's approach, and I think he's speaking to, like, you know, Damian Goodman. Of course, he's an expert in his own right, but like going back to people who have provided personal testimony and really, like, you know, getting into their stories and seeing what could come out of it in terms of, you know, potential subpoena power, like that. I think that's also something that we can look into. Are there any other comments or questions? Yeah, I guess my only last comment is that, now I concur. I think we should at least try to utilize the subpoena power. You know, if not for purposes of actually trying to get the information, but also to, you know, as someone said earlier, using this as a test because we know that the federal government is still on the hook for reparations, and HR 40 is on the table. So there might be a federal commission on reparations soon. And so in any ways in which this state task force can help further the efforts on the federal level, we should utilize our power to do so. And then also, I understand the idea that we should be cautious because, some of these entities may not have the time or the capacity, to delve through all the information. But I think we should also, I guess you could say, I think it's important for publicity reasons too, right? If we could, utilize the subpoena power and get some press from it. And then that goes into the idea of like, even if they don't respond, that's still good for us in a way. And so, yeah, so there's a lot of cons, but then I also wanted to raise that there's a lot of pros. And so, I support this motion. I would just say I would personally like to see the subpoena power exercised before the life of the task force sunsets. So are there any other comments or questions? If not, hearing no further discussion, we can call a vote. Oh, Vice Chair Brown, you are recognized. Vice Chair Brown, were you trying to speak?
Yes, I'm just trying to make.
Can't hear
You're
you.
on mute.
I'm on mute. Can you hear me?
Yes.
Yes, we can hear you.
Yes, I make a motion that we approve the measure of subpoena power.
So yes, the motion is on the floor. It's been properly moved and seconded by Tamaki and then member Scott Lewis. And we've had discussion. If there aren't any further discussion on the matter, I will call on Parliamentarian Johnson so that a roll call vote can be established.
Thank you.
Parliamentarian Johnson. Mm-hmm.
Yes, I'm calling the roll now. Chair Moore.
Aye.
Chair Moore votes aye. Vice Chair Brown.
Aye.
Vice Chair Brown votes aye. Member Bradford.
Aye.
Member Bradford votes aye. Member Grills.
Aye.
Member Grills votes aye. Member Holder.
Aye.
Member Holder votes aye. Member Jones Sawyer. Member Jones Sawyer. Member Scott Lewis.
Aye.
Member Scott Lewis votes aye. Member Tamaki.
Aye.
Member Tamaki votes aye. Member Montgomery Stepp.
Aye.
Madam Chair, there were 8 votes cast, 8 ayes and 0 nays.
Thank you. So the vote was 8 ayes and 0 nays. The ayes have it and the motion carries. The motion has been approved. Thank you very much, Member Tamaki and Member Holder, for your diligent work on the use of our subpoena power. We really appreciate it. Now we're going to move to the next agenda item, which is a discussion on the Conflict of Interest Code review and possible action. And I'll turn it to California DOJ staff. Thank you.
Thank you, Madam Chair, and good afternoon, task force members. My name is Sarah Belton, and I'm an attorney with the Department of Justice, and I'm here to address the agenda item on the Conflict of Interest Code. I apologize because it appears that my video is not coming through, and so while I'm speaking, I'll just ask one of my fellow colleagues from the DOJ to see if they can make it so I'm not a disembodied body calling in from my office. AB 3121, which created the task force, provides under Article 5, the administrative provisions, the power of the task force to, quote, procure supplies, services, and property by contract, end quote, along with the ability for the task force to, quote, enter into contracts for the purposes of conducting research or surveys, preparing reports, and performing other activities necessary, end quote. And that's in Government Code Section 8301.4, subdivisions C and D. This statutory decision-making authority granted to the task force requires a conflict of interest code. State and local bodies adopt conflict of interest codes that set out who must file a statement of economic interest and where those statements must be filed and maintained. Statements that are filed are available with the filing officer for public inspection. State law and regulation requires that new state bodies, like the task force established by AB 3121, adopt a conflict of interest code. Once adopted, codes are also subject to amendment. The statement of economic interest contemplated by a conflict of interest code is commonly referred to as a Form 700. This Form 700 is used statewide. I want to be very clear that the task force members are required to file a Form 700, and each of the task force members already completed and filed their form months ago with the Fair Political Practices Commission. The exception is the task force members who are also members of the state legislature. Because they had already filed their Form 700, the agency had their documents and did not require them to submit them again. Those attorneys who support the task force and are employed by the California Department of Justice also already filed Form 700s, but our filing officer is the DOJ. Our Form 700s are typically filed within 30 days of initial appointment, as the task force did, and then on an annual basis moving forward. This takes me to the draft conflict of interest code that was included in your meeting materials and has been posted on the website. We have communicated with the Fair Political Practices Commission about this draft. As reflected in the document on page 1, task force members file their statements, their Form 700s, with the Fair Political Practices Commission. All others who are required to file would do so with the Department of Justice. In this way, those who wish to inspect the filings know where to make a request. As is reflected on page 2, the disclosure categories for the various filers are listed. Again, the task force members and their listed disclosure categories have already applied. They've already been required to file. Future consultants and new positions may be required to file Form 700s after analysis by the Department of Justice in its capacity as legal counsel for the task force. Page 3 of the draft document includes more information on these respective disclosure categories, Category 1 and Category 2. Thank you for allowing me to share this information about the draft code, and I will be available if the task force has any questions.
Thank you, Ms. Belton. So now, given that we just got a review of the conflict of interest code from Ms. Belton, we can have a discussion if needed, or we can go straight to a possible action item of adopting the conflict of interest code. Are there any questions for Ms. Belton or California DOJ staff around this issue? If not, and this should be a short section, so, so if not, would anyone like to entertain a motion around adopting the conflict of interest code?
Madam Chair, this is pretty standard, and I move that we adopt it.
Second.
Okay. So it has been properly moved and seconded that we will adopt the conflict of interest code that was in our meeting materials. Is there any discussion on this issue? Hearing no further discussion, I will turn to Parliamentarian Johnson so that a roll call vote may be established.
Thank you. Chair Moore?
Aye.
Chair Moore votes aye. Vice Chair Brown?
Aye.
Vice Chair Brown votes aye. Member Bradford?
Aye.
Member Bradford votes aye. Member Grills?
Aye.
Member Grills votes aye. Member Holder?
Aye.
Member Holder votes aye. Member Jones Sawyer?
Aye.
Member Jones Sawyer votes aye. Member Scott Lewis?
Aye.
Member Scott Lewis votes aye. Member Tamaki? Member Tamaki votes aye. Member Montgomery Stepp?
Aye.
Member Montgomery Stepp votes aye. Madam Chair, there were 9 votes cast, 9 ayes, 0 nays.
Thank you. The vote was 9 ayes and 0 nays. The ayes have it and the motion carries. We will now turn to the next item on our agenda, which is task force contracting, discussion, and possible action item. I'll turn to California DOJ staff for this agenda item. Thank you.
Sure. Thank you very much, Chair Moore. I am going to briefly touch on a few items, specifically the authority to enter into contracts, the current contracting status, the UCLA Bunch Center interagency agreement for the community engagement program, which Dr. Grills will also discuss and update the task force on, and the funding of contracts. And then I'll be open to your questions about contracting in all aspects. The task force is authorized by Government Code Section 8301.4. And if you're looking at the bill, it's AB 3121 Article 5, to enter into 2 different sets of agreements. First, the task force is empowered to procure supplies, services, and property by contract in accordance with applicable laws and rules. That's really referring to the Department of General Services and standard state contracting rules. And the task force may enter into contracts for the purposes of conducting research or surveys, preparing reports, and performing other activities necessary for the discharge of the duties of the task force with state departments, agencies, and other instrumentalities, federal departments, agencies, and other instrumentalities, and private entities. And we've relied on that as well within the state standard contracting process. The task force is also authorized to acquire directly from the head of any state agency available information that the task force considers useful in the discharge of its duties. And I'll note here that's not exactly a contract, but we are working with the Secretary of State's office to obtain records under this provision from the state archives, which will also incur a cost, even though not technically a contract. So currently, under this provision, the task force has authorized as the DOJ's administrative, technical, and legal assistance, which has included entering into several contracts at the task force's direction. Some of these include Marnie Campbell, who is working on researching a compendium of racist and discriminatory statutes and regulations. Stacy Smith, who, as you heard yesterday, is working on the section of the report regarding the institution of slavery. Dr. Darity and Kirsten Mullins, who are economics experts and are consulting with us. Dr. Derek Hamilton, if you vote to authorize a contract, his scope of work will include methodologies for allocation of reparations. And of course, Doretha Johnson, who's with us in each meeting, who's been our your parliamentarian. However, there is no clear method. All these contracts have been entered into by the Department of Justice, utilizing the state standard contracting process to bring all of these experts into the fold for the task force. There's no clear method for the task force to enter into contracts on your own vote with your own funding. The task force would need direct appropriation and then a staffer to actually sort of conduct the contracting process. Those of you who have not yet worked in any shape or form on any contracts may not realize, but the contracting process is truly a process. There's a lot of paperwork, there's a lot of justifications. It has to go through an agency, which in the scope of the DOJ is our DOJ contracting body, and then it will go to the Department of General Services for final approval. So there has to be staff, which is why it has been done thus far through the provision of AB 3121 that you all have the administrative, technical, and legal assistance of the Department of Justice. The most notable contract, and certainly in expense, the highest expense, is our interagency agreement with UCLA and the Bunch Center for the community engagement plan. We have obtained final signatures, and just before I'll throw it to actually, why don't I just go ahead and throw it to Dr. Grills to provide a brief update about where we stand on that.
Thank you. So I'd like to offer just a few highlights about where we are at with the community engagement process. That the contracting between DOJ and the Bunch Center, as you heard, has been executed. That was supremely important because without that, it was making it difficult for us to move forward on some of the other aspects of the community engagement partners. So after extensive search that included recommendations from the task force members and community members and community groups, 2 communications firms, both Black-owned and Black-led, have been selected by the Bunch Center, and an initial planning meet and greet meeting was held that I participated in, and that meeting was last week. They are now meeting between themselves, and they will, in that meeting, carve out the areas of overlap and their particular areas of deliverables as communication firm support to the task force. In terms of the anchor organizations, about somewhere between 35 and 40 organizations were researched. 6 were selected by the Bunch Center and invited to be anchor organizations. We're awaiting final confirmation from 2 of them. Some of those organizations that were not selected from that 35 to 40 organizations still have a potential role to play as what we call tier 2 organizations. So let me just stop for a second and remind folks of what I mean when I talk about an anchor organization and a tier 2 organization. An anchor organization is a statewide or deep regional roots organization with members and or affiliates in multiple areas of the state, and who have affiliates that could be drawn upon and serve as tier 2 local anchor organizations or provide insight, access to community constituents, et cetera, to support the community outreach and engagement process. From those 6 organizations that were selected, the areas of the state that are covered include the Inland Empire, Southern California, Northern California, Central Valley, and the Central Coast. These organizations have networks, each from 12 organizations upwards to 30 organizations in their network, in each individual organization's network, with some covering 14 counties in the state for a single organization. These are all Black organizations, Black-run organizations, Black issue-focused organizations. We are trying to hold a meet and greet with the anchor organizations if we can get final confirmation from the last 2 to be held before the Christmas break, so that folks can begin to think about what their strategy will be. Now, let me mention that the anchor organizations are really running the show. And what I mean by that is that they will work collectively to actually shape and define the 10 to 12 statewide listening sessions, both the process and the content. Some of those listening sessions will be virtual, some will be in person. And these anchor organizations will operate as a deliberative body. They're going to meet every 6 to 8 weeks or so. They will decide and determine the format, the structure, and the goals for each listening session. They will weigh in on what types of listening sessions should be held based on considerations related to issues that should be heard about, regions and locations in the state that should be covered, and third, constituents and or special interest groups or populations that should be heard from. They will help situate the listening sessions within the context of past and current Black-focused social justice campaigns that uplift reparations areas that should be within the purview of the task force, the kinds of things that we've been hearing from our expert witnesses. They will also provide feedback and input to the communications firms who will be working alongside the anchor organizations in messaging to both educate the general public about the listening session, about reparations, to try to get the word out and support the efforts of the community organizations and groups. The last thing I'll say is that the Bunch Center has also selected a professional facilitator who will do the actual facilitation of all 10 to 12 listening sessions. And Bunch Center has also selected a convener of the anchor organizations, someone who is going to actually moderate the meetings of the anchor organizations and ensure that there's ample coverage across issues and across sectors of the state. Let's see, I think, oh, there is one last thing, and this one is particularly exciting, I think you'll agree with me. With the help of member Tamaki, he and I held about 4 or 5 meetings with city and county entities who are also looking into reparations issues. That includes LA City, County of Alameda, City of Oakland, City and County of San Francisco, City of Sacramento. And in the course of those meetings, we wanted to find out what were they doing, let them know what we were doing in terms of community engagement, and find out whether or not there would be a benefit or a value added of working jointly. They were all very excited and interested, and so now what we're going to have the benefit of is meetings with these city and county entities to align with the community engagement process, so that, for example, if we're going to be doing something in the Alameda County area, then we would be able to draw on the work and efforts and contacts and networks of the County of Alameda and the City of Oakland to support our outreach efforts, to support the messaging, to share with our anchor organizations and our task force information that they have about the harms in their local area, and we can do the same with them. So I think that will really enhance the community outreach process. When the task force meets again in January, with all of the invited participants in place, we would be able to then share the names of the anchor organizations. In terms of those tier 2 organizations, who will be selecting them? It will be the anchor organizations, and of course, any recommendations, input, ideas from the general public about that. I have actually been checking the chat and found and listening to some of the recommendations from our expert witnesses, and that has been helpful in helping me to continue to grow a list of potential participants in the design and the implementation of these listening sessions. So that's the update.
Thanks so much, Dr. Grills. The last thing that I will just say, and then I'll open it up for any questions you may have for me or obviously Dr. Grills, is one of the questions that I had received in an earlier meeting was a question around the funding and budget for the task force. members have talked about. And, just in this context of these contracts, there is no clear method for the task force, as I mentioned, to enter directly into contracts because they go through staff in this process. But beyond that, the task force would need direct appropriation. Right now, the task force's contracts, including the contract that Dr. Grills was just speaking of, are going through the Department of Justice for both process and funding. We anticipate continuing to do this at the task force's direction. So even though it's not exactly the task force voting on and entering into its own agreements, it's essentially the way the statute is written. The task force will vote to direct the engagement of contractors, and the Department of Justice staff will go through the administrative process and account for the budget in order to do that. And if you want more information about the contracting process, the Department of General Services website has a detail regarding what that process entails. It's all public and a standardized process. So anybody who wants to look at what that process is welcome to review that. With that, that's the end of the information that I have to present. I'm obviously happy to answer any questions anybody may have.
Great. Thank you so much, Member Grills and Attorney Newman, for that presentation. Are there any comments or questions to either California DOJ staff or Member Grills? Member Tamaki, you're recognized.
For more. I just want to thank the Department of Justice for getting the contracting process through, and in particular with UCLA. I realize it was a monumental effort because things just necessarily take a long time. But now that that's in place, UCLA was kind of extending services on credit, so we appreciate that. And I want to thank Cheryl Grills for doing really tons of work to set up this engagement process. It's complex, and but it has this is thanks to Lisa Holder and Cheryl Grills and the task force, have the foresight to build in the communications component, because that is key. And the press coverage has been sort of limited up until now, because there really hasn't been something newsworthy to report, although the testimony has been riveting. But I think when the community engagement process begins, to echo Erica Alexander, one of our witnesses, the actress and producer and writer, who's talking about the importance of personal narrative, personal story. I think that's key. And based on our experience with Japanese American redress and reparations, although again not comparable, lots of differences with Black reparations, we didn't get any traction until the personal stories began rolling out. And that's when, as Ms. Alexander was saying, the humanity came out, the press stories came out. I just think it was just really, really valuable. The other piece of it is, I think the government, the local entities, the cities and counties are really going to benefit from the report. They don't have the resources to produce what this task force is producing in terms of, a comprehensive, well footnoted, authoritative report on the harm. And but that is available. That will not only fuel and help, the local entities and that movement, but also, other areas. So I think I agree with Dr. Grills. We're kind of turning the corner to a really interesting part of the task force. So just want to throw out my thanks.
Absolutely. This was a monumental effort, and extremely indebted and grateful to Member Grills for the work you've been doing behind the scenes to get this established. I'm definitely looking forward to the community engagement process. Are there any other questions and comments? I guess I had a clarifying question for Attorney Newman. Sorry, Member. I didn't see any. Thank you. We'll go to Member Bradford and then Member Montgomery Stepp.
Thank you, Madam Chair. I just had a question. Does the task force have any say in the 2 communication groups that are selected, or the 12 anchor groups? And I'm just curious, who are those 2 communication companies that were chosen?
Do you want me to answer that, Michael?
Oh, yes. That's all going through Bunch Center, so.
So the contracting was with Bunch Center. So Bunch Center is making all of the decisions. However, the communications firms that were reviewed included any recommendations from task force members. The 2 final selected communications firms was AB Partners and Young Communications.
And the 12 anchor groups?
But they declined the invitation to do the communications. Thank you.
That was a little broken. I was curious. I was curious about the 12 anchor groups as well.
No, it's not 12 anchor groups, 6 anchor organizations. And the task force members shared an Excel spreadsheet that listed recommendations on potential anchor organizations. All of those anchor organizations were included in the list of organizations that the Bunch Center vetted. A spreadsheet was created to try to discern the size, scale, scope, reach, areas of focus, location in the state that they could touch. And so some of them were more robust in their reach and their capability than others. And some were not able or interested at this time that may have been recommended by task force members.
Okay. I still had a few more questions, but I'll stop there. Thank you.
Okay, I'll go to Member Montgomery Stepp.
Thank you, Chair Moore. Member Grills, I just also want to thank you for your work on this. I also want to offer up my office in San Diego as a council member of District 4, which is our historically Black, and also under-resourced community. There is a growing interest. Of course, we're juggling a whole lot, so been trying to get the word out the best that we can, but with a concerted effort in this new year, I am kind of giving up some of my other responsibilities to put even more time into the task force, and also assigning a staff member. So I would love to be a part of getting the word out with regard to outreach. One of my comments around the outline with DOJ was that there were no San Diego references there that I could pick up on, and there's a lot of discriminatory practice in San Diego, and so I want to make sure it's on the record, and just offer up my office to help with the outreach, because we have a far reach in San Diego. So thank you, and I hope the Bunch Center and the task force will take me up on that. Thank you.
I have a quick question. Thank you, Chairman.
Yes, you're recognized.
Dr. Grills, yeah, your work has been phenomenal on this. Thank you for all that incredible follow through. Now that we do have a communications team engaged, I would imagine that between the 9 task force members, we have a massive network. For outreach. And I'm wondering if there is some sort of systematic way that we can put together that network, so that all the people, all the groups that we've worked with, all the activists that we know, the church organizations, et cetera, can get information and updates about when the meetings are going, where the listening sessions are, and that's a massive resource that we can compile collectively and maybe hand over to the communications people. So is there a plan to put together some kind of spreadsheet of our network?
Yeah, so that's really the work of the anchor organizations. When they have their first meeting, they kind of need to do a landscape analysis, looking at what we've already heard, what we are planning to look at, what we may have missed as a task force. And then they're going to come up with a set of recommendations on the who, what, when, where of these listening sessions. That information, Bunch Central will be, kind of funneling information back and forth to the task force about each step of their planning process to get your feedback, if you have the connections and the ability to support, what is being selected for these listening sessions. We are hoping that the task force will be able to do that. And also at each listening session, I believe we will not be violating Bagley-Keene if 2 task force members are present at each listening session. That is the hope, that at each listening session we will have 2 task force members, and we can triage ourselves to the listening sessions that make the most sense given our areas of expertise, our particular geographic focus, the topical issue, et cetera.
And then in addition to, advertising and being on the content of the listening sessions, will the communications team be advertising our task force meetings so that we can get more, the public more engaged?
Yeah, that's one of the things that they are planning their, I forgot the term that they use in communications, but they're planning their strategy, and that strategy does include communicating to the public about who the task force is and what we're doing. And so I would imagine that that should include when our meetings are occurring, and trying to figure out how to inspire community participation and coming in and listening, particularly when there's a topic that is of particular relevance to a member of the community.
Thank you.
I would just real quick also suggest making sure the Legislative Black Caucus is in that loop of disseminating that information. I think with our network, it's key. You have 11 members now, so we would love to be engaged as information is going out.
Yes, Member Tamaki.
I would just add the importance, this is echoing Senator Bradford and Lisa Holder, about the communities out there other than the Black community that we need to, in the Asian American community, there are numbers of groups who are eager to help and support and spread the word about this, and certainly in other communities. So it's really important to, with the resources of the communications firm, to have a the broadest possible outreach. And I would include also the Asian Legislative Caucus and other groups because they would want to support this.
Yeah.
I had a follow-up question. So will the communications firm, will they be able to create a website for us? I think we probably talked about this earlier. I just can't remember, like a separate website to hold all of our testimony and, just a space to have that's separate from like the DOJ site.
There is a website that's going to be created. It's going to be Bunch Central, I believe, is taking the lead on that. And because literally some of these things have just been decided, and the meet and greet was just last week. They still need to kind of lay out like what's doable within the scope of resources that we're able to provide. And I should mention that when it comes to communications, that gets really expensive. So Bunch Center and I worked on a grant proposal that has been submitted and is currently under review and looking pretty good to supplement the funds so that we don't have to sacrifice on how extensive our community outreach and our communications process can be.
Great. Yes, I guess another note, and I guess we can talk about this when we get there, but we have all this video testimony, so it would be great if like the communications firm could like use that video, maybe cut some like powerful parts and then use that as part of outreach as well. Just putting that out there as an idea.
Right, and yeah, and to the point that was made earlier in the expert testimony, they are very, very mindful of how important and powerful storytelling is. So I think that they may be drawing on a number of sources to create some stories that not only just educate folks, but that also speak to people's hearts around, the importance of doing this work and the importance of being careful around how we are defining reparations and what we consider to be appropriate and satisfactory forms of reparation. I should also mention that because again, well, I'll just say it.
Sorry about that.
The point of community listening sessions is not to box people into a predetermined frame on what is reparations and what form reparations should take, but rather to give people a kind of level playing field of basic understanding of the range of ways that people are looking at reparations, the range of ways people may be defining what are appropriate reparations, and then let's hear what people really think. So in terms of the communications process, as I understand it thus far, the anchor organizations are not going to come out with a definition of reparations. That defeats the point of a listening session. Because if I'm going to tell you what it is, why do I need to hear from you? And if I'm going to tell you what the form of reparation should be, why am I talking to you, right? So you can co-sign. So we really want this to be an open, conversation where people's thoughts and perspectives can really come to light. And then we can deliberate, with that information, with the benefit of that information.
Thank you. So I just have one last question. It's for Attorney Newman about the contracting process. Thanks again for giving an overview of the idea of contracting. So if I heard you correctly, you're basically saying while AB 3121, the bill text provides a power for the task force to utilize contracting power, there isn't really a clear-cut process to do so, and there aren't any direct appropriations that the task force has to enter into such contracts. So like hypothetically, I was thinking, let's say we maybe the anchor organizations, for instance, might propose like enlisting a genealogist, to as a way to like help with the storytelling aspect of our effort. Would that entail the task force having to enter into a contract with like a genealogical society or a particular genealogist? And if so, is your response is that we may not have that money to do that, and so we would have to ask the legislature for that money to do that? This is just a hypothetical situation to help me understand better our powers.
Sure. And it's a little bit difficult to answer in a vacuum. I mean, we would certainly, if the task force voted that they wanted to retain somebody and direct the Department of Justice to pursue a contract, we would go ahead and pursue the contract. And theoretically, if we were rejected by the Department of General Services or budgets or something like that along the way, we'd come back and report back to you. But thus far, that has not happened. And I can certainly tell you that, for example, just the Bunch Center contract alone is pretty significant. So it really would be, we'd have to sort of experience that. The other issue you raised, potentially if the anchor organizations or some other contract wanted to pull in a contractor or somebody to assist them, they would have to go through a subcontracting process. That may require going back to the original contract, and it gets very complicated. The other issue is, in some instances, we are required to have contract bid processes. Depending on what we're contracting for and what the particular rules are with regard to that contract, we'd have to put out a request for proposals. People would have to respond with their proposal, and then the task force would have to determine which the winning bid would be, and that's subject to a whole different set of rules. And so that might be something where you say this is the amount of money that the contract would be for. The people who are interested in obtaining the contract would have to provide their proposals, and then the task force would have to determine their bids. All that being said, the bottom line is the task force does not have its own appropriation. And thus far, everything's been coming through the Department of Justice pursuant to the statute, saying the task force, has the administrative assistance of the Department of Justice, and every contract that you all have voted to enter into, including the Bunch Center contract, has gone through our normal contracting process. And so that's been the process that's taken place. If there were, I don't know, we'd have to look into an alternative methodology, whether the task force would get an appropriation and therefore have the ability to do direct contracting. It still would need to go through the Department of General Services and go through the normal standard contracting process. And like I said, in some cases would require bidding rather than just contracting with specific contractors for specific reasons.
Okay, thank you for that. Are there any other questions? Yes, Member Holder, you are recognized.
Yeah, a quick question for you, Michael Newman, about our contract with Dr. Hamilton, the economist. I just wanted to know, is there going to be some further discussion of that issue? Because he did put some stuff on the record that made me think that we need to expand his contract, or at least discuss, that contract. So is there going to be further discussion at this meeting? Is that slated for another meeting? Where we are on that?
Chair Moore, do you want to respond to that?
Yeah, we're going to discuss it today during the unfinished business portion.
Okay, thank you.
Yes, no problem. So are there any other questions related to this agenda item on task force contracting? There is potential action item, but from the discussion we're having, I don't hear any action item coming out of it. I think people just had questions. I think they've all been addressed. So are there any other questions? Also, if anyone would like to entertain a motion related to this agenda item, this is the time to do so. If not, we will turn to our break. Good, we are 15 minutes early. So,
Chair Moore, if I may.
Member Montgomery Stepp, you're recognized.
Thank you. Just real quick, this question is from Mr. Newman. I know we don't really have a process for contracts. Is there a way that task force members can review contracts even after they've been executed, or would we have to make a process for that? Would that be a request, to the chair, or what? What can we do just to see if we want to see contracts? Because we now have one that has been executed. The names of some of the organizations have been put on the record, although they are not technically a part of that contract. Just if I want more information, what do we have to set up a process for that, or can I ask directly?
Sure. So first is all contracts are public. They go through the Department of General Services. There's no, even with limited exceptions, even a confidential investigation at some point they're a public document. We're spending public funds, so fully transparent. I think Dr. Grills the idea is potentially for the next meeting that the Bunch Center interagency agreement will be included in the meeting materials. It's just been finalized. It's just been signed, and so that the late breaking word on the finalization meant it wasn't included with these meeting materials. And the other contracts, if you would like me to, I can go ahead and include those in the next meeting materials, but everything is public and available.
Okay, and so, yes, and thank you for that, because I know public contracting, but I also know sometimes people have to PRA stuff to get it, right? So I'm glad we have a forum where they are available. At what point or when after they're executed are they uploaded for public view?
I think they're available soon after execution through the Department of General Services, I think. But we can also share. I mean, you'll see from the contract materials that there are pretty standard terms. So it's not like there's a lot of there's not a lot of back and forth. I think I'm trying to think the terms of, for example, the contract for Dr. Hamilton. I think that they were shown yesterday. May have been in the materials. I'm not exactly sure about that, but at any rate, the key thing is, does a task force want to enter into a contract? What should the scope of the contract be? That's all something that you all are involved in defining in these meetings, publicly, unless you designate a member of the task force to do that on behalf of the task force. So the terms of the agreements aren't going to differ in terms of the documents that are executed. The key is just, are you directing us to enter into an agreement for the task force benefit, and what are the terms? So when we talk in the unfinished business segment about Hamilton's contract, in essence, you all are determining what that contract is, whether we enter into the contract. And so you're aware of the scope from that conversation, because we don't diverge from that. And like you're seeing, the original conversation, the scope involved both components of the statute. We had follow-up discussions, and now the scope involves only one of those components. So whatever the task force's direction is, what we're executing on in entering those agreements. Anyway, that's a long way of saying you all are telling us what to do and what the scope of the contract should be. And so the final contracting scope includes what you've laid out, and then all the terms. Most of the terms are just standard otherwise.
Thank you.
Okay, thank you. Any other questions or comments or concerns for Attorney Newman or Member Grills? Okay, so hearing no further discussion, we will close this agenda item and move on to the next, which is our break, which is supposed to occur from 2:45 and 3 p.m. So Parliamentarian Johnson, I have a question. Can we break early? Is that possible? And then return at 3 p.m.?
Yes, you could break early.
Okay, thank you.
Objection, you can, yes.
Are there any objections to breaking early? Okay, hearing no objections, we will break early and return at 3 p.m. Thank you.
All right, now we're on break. We're on break. I see you guys. Let me give my shout outs to my soldiers, my comrades, my tribe. I see you, Michael Jordan, BB Rodriguez. Let's see here, Danielle Witten. Hi, fam. Shauna Kim. Hi, fam. Oh, let's see. I saw some other folks. I saw Miss Powell earlier. BB Rodriguez. Thank you, love, for joining us back. And for those of you who have yet to chat where you're slinging bricks from, welcome one and all to the live. We're on a break, so I'll just chat a little bit about today and, talk about what just happened. What you're seeing right now, family, is the inner workings and the inner machinations of how reparations happens. This is a long, arduous process, and many people are telling me that they're wondering, what Plan B is. Michael Jordan, he was asking me, let me silence this phone. Good Lord, it's going off. It's busy at Reparations Central, y'all. It's busy. But anyway, Michael Jordan was asking, what if this is not robust? What if this doesn't go through? Family, what we're doing in California is trying to set the stage for proposals that will set the standard for the federal repair. So what I need for us to do is to, let me put my face up here, y'all. Hold on one second. There we go. What I need for us to do is to put all of our energy into its manifestation. Because, family, if you've been tuning in, you can see that we are really in dire straits. I shared earlier today that the median wealth of Freedmen, per the Color of Wealth LA report, copywritten in 2016, is 4,000 compared to Nigerians, 60,000 compared to 72,000. I'm sorry, compared to Japanese. We're leading the pack out here in California, at least Southern Cal. We're talking LA, Los Angeles. And so let me go back and tell you true. I don't want to just talk out the side of my neck. But yes, okay, so Japanese were at 592,000 in terms of median net worth. Asian Indian Kamala people was at 460,000 median net worth. Chinese 408,200, white at 355,000, Filipinos at 243,000, African Black 72,000, Vietnamese 61,500, Latinos 42,500, Koreans 23,500. Now, although at the time of this study, freedmen were 44% degreed as compared to Mexicans at 17% degreed, our median wealth was $4,000 as compared to Mexicans at $3,500. Now, what you have to understand, family, I want to point out, there is a difference between Mexicans and Latinos. As you heard me state, Latinos really identify as white predominantly. Their median income as a result is $42,500. And they're really from like South America. There's a difference between the Latinos that come from South America as compared to those that are Mexican. Okay? The Mexicans are more like, let me not say that word. Anyway, they are the poor. They are the poor ones. Those are the ones that are at the border trying to get over. They're sending their kids over, and now they're making a case, leveraging or weaponizing the ACLU to sue the government. And they're now talking about 450,000 per illegal who got separated from their families at the border. What you're experiencing here, family, is this government being complicit and giving more of our reparations away. Now, why would they do that? Because they need the vote. And by and large, immigrants vote on the lines of conservative. Latinos are more conservative in the way they're voting. And so they're trying to make they're trying to weaponize immigration against us to not just neutralize us economically, but now they're coming for the vote. And when you see these type of settlements being touted about, when you see illegals getting reparations in New York, they're getting the rights to vote. They got like 16,000 apiece during the pandemic. Like when you see all of this going on, it is absolutely the Democrats buying the vote. And the reason being, family, is because our vote, they can't rely on it anymore. We are awakening all over the place. We're demanding reparations. We're demanding tangibles in exchange for our vote. And so they're looking to flood the country. The Biden administration is flooding the country with refugees and immigrants because they need to grow their base of support so they can guarantee their elections and shore up the elections for the next few years. Okay, that's really what they're seeking to do. Now back to the text I shared with you earlier. These were some of my comments at the top of the hour. One of my comrades said it was going in and out, so I may have to do the whole thing over in January. That was not my intent. We will see. I'm going to go and play it back to see if it was choppy. Because if it was breaking up, then I have to do it over. But anyway, of the 3 trillion household dollars shared by all the Blacks in this country, comprised of 90% freedmen, 10% immigrants, that's more like 86-14 now, but I just rounded up. 2.3 trillion household dollars is shared by the 10%, predominantly immigrant, and less than 700 billion since COVID is shared by 90%, predominantly freedmen. Okay. Now, the median home price in LA is $790,000. Okay. And this is why we cannot afford to put our energy into what if it don't happen, plan Bs. You know what I love about Denzel Washington? He said he succeeded as a performer because he didn't have a plan B. Now, I don't recommend that for your regular lay person. That's a huge gamble, right? But we've got to put all of our energy as freedmen into its manifestation, because as go California, so goes the nation. Okay. Now, the median home price in LA is $790,000. Now, back in 2016, if our net worth was $4,000, how in the world are we going to survive without the reparations manifesting when the median home price in Los Angeles, the same place where the color of wealth data was accumulated, is $790,000 and we've got a net worth of $4,000? That means, family, even if you're fortunate enough to own a home, you can't borrow against the equity to build a business. You can't borrow against the equity to educate your children. You are pretty much already homeless. You just don't know it yet. That's what's going down. And that's why there's a great migration out of California. We cannot afford to be here if our median net worth was $4,000 in 2016, $500 more than Mexicans when we are 44% degree to their 17%. How are we in a race to the bottom with Mexicans? It's exhausting, family. So no, we cannot entertain not succeeding. We have to take the mustard seed of faith and put it to work and put all of our God minds around its manifestation, because what is true of California is happening all over the country. Excuse me. We've been legislated to the bottom, family, as the anchor of this country's capitalism. And yeah, that's problematic. Okay. It's a huge problem because it's going to take legislation along with money to get us up off the bottom. What we are in the midst of right now, family, it's not just the fight to get up off the bottom as the anchor of the country's capitalism. We are in the fight of our lives for our very survival. These plans are designed to genocide our people. You must understand what this government on both sides of the aisle is complicit in doing to freedmen. They are seeking to genocide us to as few in number as the Indians. They are seeking to replace us with the migrant class. You must wake up. You must get into the fight. You must find out where they're fighting near you. And you must fight to your last breath. I mean, seriously, family, we don't have time for the kicks and the giggles. We are out of time all over the country. And so, yeah, I know that my energy is a lot. Shout out to Michael Jordan, who commended me on my fire and my passion for freedmen. But like I told him, I'm not for everyone, and I was born to set it off. So that's what I do. And, like I was trying to explain earlier and lost my train of thought, I am not anti-immigrant. But what I am absolutely not is immigrant over freedmen. Do I need to repeat myself? I am not anti-immigrant. I am anti-immigrant before freedmen. I am immigrant before freedmen. Not anti-immigrant. I am immigrant before freedmen, meaning you don't have a right to use our reparations and tax dollars to make refugees and immigrants whole before you settle the debt owed to freedmen. Okay, so that's not popular with everyone, and me saying it and making those distinctions is not favorable, but I must, because I will not sit quietly in the gas chamber next to freedmen and just be silent while the genocide is being leveled at us at every turn. Okay, this is not your plight. The freedman plight is not your plight when you're boasting the numbers I just read off to you. When you're in those communities, the color of white is green. So by way of your green, immigrants and white folks alike, you've got whiteness to your credit, because the color of whiteness country is what, family? The color of whiteness country is green. So you're well taken care of. And so your blues will never be that of freedmen's. But we are working to end our 500 blues, our 500-year blues. We're working to end that. Let me see what else y'all talking about. Angela is the truth. Oh, yes. Angela, thank you, BB. She said, Angela is the truth. Okay. Okay, so support the community. Okay, great. I'm not even going to do that right now. Angela, weaponize. Okay, let me see. She said, Angela, weaponized against U.S. the vote. Yes, we must weaponize the vote. I keep telling you guys over and over again that a trifecta of either party is the death knell of freedmen. I keep telling you. Folks don't want to hear me. I don't know when they're going to listen to me about the weaponization of the vote, BB. Maybe when we're no longer here to talk about it, because that's exactly what's happening. How in the world are we at a median net worth of $4,000 and a median national income? Oh, what was the median national income? I want to say the median national income for freedmen is $30,000. So if what I was saying was not true, that both sides of the aisle are complicit in how we got to the bottom of this Titanic, then I guess you could push back on my chess strategy with the vote. I've told you guys many times, Dr. Charles Morris of Abyssinian Church told Teddy Roosevelt's administration after we delivered them the White House that you shot us when our guns were empty. And for that, we're going to return the same. by delivering a blue top of the ticket and a red Congress to protect the Black South. What was he talking about? What did Teddy Roosevelt do to make him decide it was time for Blacks to weaponize the vote? Teddy Roosevelt dishonorably discharged 167 Buffalo soldiers who were wrongfully accused of murdering a second white man after being quarantined in their barracks for having been wrongfully accused of murdering the first. Dr. Charles Morris knew way back when, in Teddy Roosevelt day, that we're not going to keep giving you the White House and you are giving us your ace to kiss. We're going to stop that. We're going to weaponize the vote. So what I'm suggesting is no different. For the life of me, I don't understand how 87% of our electorate went out and voted for an administration that told you from the gate, from the campaign trail, they're not doing nothing for your people. As if you didn't get enough of an Obama. I don't know how in the world we decided that Trump was more of a racist than Biden. When Biden was the author of the 94 crime bill and has called us every manner of thing and believed that he was a segregationist. And yet we rushed to the polls to unseat the overt racist in office of 4 years with no record against Freedmen, with covert racists in office for a combined 60 years, with records several New York City blocks long against Freedmen. Both know Biden and Kabami alike. And this is what we thought was a novel ideal. When all we got to show for it is $6.5 billion going to the Afghan refugees, $350 million plus protections to the AAPI, another $31 billion to the Indians. They've been getting repairs since 1866. And folks want to talk to me like we're going to get reparations for a one-time cash payout akin to the Japanese interned. Oh, no. See? Y'all got me all the way mixed up. If you think this is one check and done, you got me all the way mixed up, boo-boos. That's not what I'm fighting for. I'm fighting for our generations to be paid into perpetuity. Me and my comrades, because you still got the oppressive boots on our neck. I mean, if you showed up for the task force hearings from the inception 6 months ago, you would hear through all the testimony how this is not just for slavery. It's not just about Jim Crow. It's for accrued, ongoing, systemic racism, oppression, and disadvantage in the country our ancestors built with their lives. You think that's a one and done? You got me mixed up, boo-boo. That's not the fight. Oh, no, see? That is not the fight. We are owed on the very low end per Thomas Kramer, who calculated our damages just for slavery at 3 cents an hour, compounded over 6% from the time of our emancipation, from the time of the formation of the country in 1776 to the end, our emancipation in 1865. Not that ended slavery, right? We got the not so new slavery in the private prison industrial complex, but just for slavery alone at 3 cents an hour from 1776 to 1865, compounded at 6%, that was 6.2 quadrillion. Okay? And I don't want to hear from you talking about the number is too high. That's not my fault. You should have never took our 40 acres and a mule to give it to the white folks in the form of a Homestead Act for 100+ years. You set up white immigrants and paid slave owners. Okay? So please miss me with it. I'm not fighting for a one and done. I'm fighting for our lineage to not just survive, but to thrive. And today, as a part of my public comments, I talked about protections. I talked about enforcement. I talked about the sentences for the white glacier donkeys who decide they're going to try to lynch us and burn down our Black Wall Streets all over again. I talked about how they need life sentences without parole in maximum security prisons. See, those are the kinds of laws that will protect us the next time we get the very first time that we get reparations. We've got to think about all of that. We got to keep a secure gate up, so white women and the LGBTQIA and the immigrants won't find a way to co-opt it like they did affirmative action. Okay, it's a lot of work. And nobody wants to do the work, but everybody's happy when the money starts to deposit into their bank accounts. You know, Michael Jordan says, the Democrats and the Republicans with the 3 Ks are not our friends. That's funny, Michael. I call them repugnant cans because they're repugnant, okay? Michael says, we must also make sure reparations is not a housing voucher like they trying to pull in other local reparations places. Absolutely. This is that fight too, because you got NARC and Cobra at the table for the HR 40 with Sheila Jackson Lee, who migrates from Jamaica, running our reparations and are not even factoring in. They're not even factoring in our edits. They are locking Freedmen out of access at the table of their own reparations study on a federal level. That's why we're at this table, fam. We're at this table. And if you ain't at the table, you on the menu. It looks like they're trying to come back, y'all. Angela is the TR roof. Yes. Yes, fam. I hope no punches. As you should. Set it off. Thank you, family. No gatekeeping is necessary now. It's always been necessary. Somebody dropped the ball. Tell it, Angela. How do we deal with these do-nothings who want checks without putting in the work? Family, all of our leaders prior to now had this same fight, family. All the looky-loos who, are straddling between belief and disbelief will sadly not do the work. I'm just here for those who want to get in the fight. I'm here. Tell it, Angela. Okay, so there we go. At Ms. Powell, you should be supporting anyone with the Freedmen consciousness and putting them in local positions of power, authority to legislate federal policy like reparations. Oh, Ms. Powell is putting in work, fam. She's putting in work. Lots of it. Okay. All right, family. They're very active in the chat. If you want to chat and get involved and get engaged, you have to come over to ScrewTube. You can't do it. I can't see your comments in Facebook. Shout out to Facebook and Twitter. Y'all been holding in strong.
It is now 3 o'clock.
Okay, here we go.
Before we continue to the agenda, I will turn to staff so a roll call for attendance could be established. Parliamentarian Johnson?
Yes, thank you. Yes, Chair Moore.
Present.
Vice Chair Brown.
Present.
Member Bradford.
Here.
Member Grills.
Present.
Member Holder. Member Jones Sawyer. Member Scott Lewis. Member Tamaki.
Here.
Member Montgomery Stepp.
Here.
I will call again. Member Jones Sawyer. Member Scott Lewis. And there are 9 members of the task force. 5 members are needed for a quorum, and there are 7 members present.
And for the record, Member Holder is present.
Member Holder? Oh, thank you. There are 8 members present, and we have a quorum.
Thank you, Parliamentarian Johnson. So now that a quorum has been established.
Madam Chair, I made an error. There are 7 members present, and I had counted Holder. So there are 7. Thank you.
Thank you very much. So there are 7 members present. That means a quorum has been established. So we'll continue to the next item on our agenda, which is setting future meeting dates and Saturday meeting dates, review, discussion, and possible action item. So I'll also turn to Attorney Newman to assist us with this part of the agenda. Thank you.
Sure, no problem. So there's a couple of items here that are all sort of part of this discussion. Number one, as you all know, we circulated a doodle poll, which the members responded to for the January meeting. The two dates that were selected are the dates that we circulated, which are the 27th and 28th. That is a Thursday and Friday. There was no quorum for Saturday the 29th. So we're gonna come back to the sort of the agenda for the for the next hearing in the next segment. But I'm telling you this as background for sort of point one, which is the task force, wanted to consider Saturday meetings. And part of that is going to be the availability of task force members for those Saturdays. I just wanted to alert you as to why the next meeting is not scheduled for a Saturday, but rather a Thursday and a Friday. The other thing that I wanted to mention in considering the agenda for the next hearing, first of all, we didn't get enough responses for a quorum on any dates in February and March. We did get one for a quorum in April that included a Saturday, but before we start setting those dates, which the task force does not need to vote on in this meeting, but we will recirculate a doodle poll and potentially revisit the hearing dates in the January meeting. I wanted to mention, based on my update yesterday, that the task force meetings will now be shifted to be in public after the January meeting. And in addition to considering the dates that people are available, that'll include consideration of the dates that people can travel. If the task force continues to have 2-day meetings, it will most likely necessitate travel on the day before the meeting and return travel either late at night or the next day after the meeting. And so, for example, if we had a meeting on Thursday and Friday, probably most members would need to plan to travel on Wednesday, by Wednesday night, arrive in the city in which we're holding the meeting, have the meeting on Friday and Saturday, Thursday travel, Friday, Saturday meeting, if you choose to have it on Saturday, and then Sunday travel home. And so I think that bears some discussion as to how the task force would like to approach the meeting setting when we can start to convene in person. The other issue that needs to be addressed is, well, I guess we'll talk more about travel coordination and how that would work. But the other thing that needs to be considered by the task force and factored into the members' travel planning or planning ahead for which days they're available is whether the task force wants to have all of its meetings in Sacramento or plan to have meetings that rotate. I think Dr. Grills can speak potentially to the community engagement meetings happening sort of all over the state. And the task force also mentioned, I think, raised in its initial meeting whether or not the task force wanted to have in-person meetings if it went back to in-person around the state. And that's something that I would also encourage you to consider in voting when and where, in voting where to have the meetings in February, March, April, or May, so that task force members can consider that location when answering our doodle poll as to when they would be available to actually attend the meetings. I know I've just mentioned a whole bunch of different considerations, and I'm not asking the task force to set the meeting dates right now. That's something we can do by the doodle poll. But I think the key questions are, focusing on Saturdays and then locations for the in-person meetings so that the members can figure out their travel plans.
Well, I wanted to raise something, and I'm not sure if it further complicates anything, but so once we meet in person, we then have up to 10 reimbursable meetings left. And based on the public hearing proposal that we adopted earlier on in this process, technically starting in January, if we include the technology and health panels, we would have 1, 2, 3, 4, 5, 6 meetings left. So I say that to say, I'm not sure if this is the time to do it. Maybe we can take the time to do this in January. So we have some time between now and January to rethink the public hearing proposal that we adopted, because it seems as if we now know that we're working with a bit more time, in the sense that we have those 10 meetings that are reimbursable. And so the meetings themselves may need to be restructured. Maybe we don't need to have 2-day meetings back to back anymore. That's just something to bring up.
If you're looking for a comment, I agree. If you're having in-person meetings, I think we'll be able to tackle far more information in person versus the current situation on video.
We'll have to revisit that. But in terms of possible action items for this particular agenda, Attorney Newman, again, we're not going to decide the potential dates here and now. We have to revisit through a doodle poll. So I'm actually kind of unclear as to what potential action items should come out of this, other than, I'm just unclear about a potential action item. I think this is just kind of like an information item.
Well, sure. I think the biggest potential action item that I think we would need direction on. So when we circulate that doodle poll, if the task force would like to plan to have meetings all in one location, or have meetings that go to different locations, I think it'd be important when we do the doodle poll for February, March, April, and May, or whenever the task force would want to schedule those meetings, that we be able to include the location so that members can factor in the location to their availability. For example, if something is in Sacramento, a member in San Diego may need to plan for travel getting to and from Sacramento, in addition to being in the meeting. And then the other factor in that, as you just raised, 2-day meetings or 1-day meetings, that would be another factor in people being able to respond to the doodle poll. The idea is we would plan to get this information from all the task force members, report back in the January meeting on when we have a quorum for in-person meetings, the various dates for the task force to decide and set the at least February, March, and April meetings. And I'm just talking about setting dates. The second issue you've raised with regard to subject matter, if looking at the presentation that you gave Chair Moore in, I believe it was the second meeting, we're already up to sort of, I guess we could call it part of meeting 5, in that we've now public health. You are now going to consider public health on its as a meeting along with technology, which leaves history of policing and war on drugs, the criminal legal justice system, and then getting into the discussions on legal considerations for reparations, exploring reparations in the form of compensation, exploring reparations in the form of restitution, exploring reparations in the form of rehabilitation, exploring reparations in the form of satisfaction and guarantees of non-repetition, proposals for reconciliation. And those are the topics that were covered in the original proposal, which is on the website if people want to check that. So we could come up with a couple of things, and partly this is at your direction. I do think we need to, in the next segment, sort of confirm the January meeting date and the agenda. And then coming out of this section, I think we would want to have a vote of the task force on a plan for locations. And if you, Chair Moore, or somebody, or want to delegate to another member or to DOJ to come up with a plan for addressing all of the remaining topics or any additional topics that were not included in your original proposal.
Okay, thank you, and that was helpful. So I guess we could maybe start the conversation, unless other people have any comments or questions for Attorney Newman about the idea of whether, once we have to start meeting in public, do we want to meet in one single location, or the other alternative with meeting, wherever we are, but obviously with the caveat that that location has to be open to the public. But then for me, that begs the question about, if we are all in different locations, which is, fine with me, how are we going to, stream it? Make sure that, we'll talk about that later. But anyways, let's just stick to the basics about what are our feelings around meeting in one central location or the other alternative. Does anyone have any strong feelings around that?
Let me get a clarification here.
Yes, please.
So I just want to know what is the other alternative? Is the other alternative that we meet separately, or that we meet together in a place that's not Sacramento?
That's a great question, and I can see it was a little bit maybe garbled. So there's really two options, and I'm speaking now macro options. There's two options. One is pick a place and meet there, maybe Sacramento, and all of the meetings will be in person in Sacramento, or choose to have the meetings on a sort of rotating basis where it's still the entire task force meeting together, but having that location change. So the task force meets in Sacramento for one meeting. The next meeting is in the Bay Area. The next meeting is in Fresno. The next meeting is in Los Angeles. So those are the two options I'm talking about now. What I think you may be asking Member Holder and Member Chair Moore, you may have mentioned. So there is a whole separate conversation about if somebody can't make it to the meeting in person, or isn't able to travel, or just doesn't. That's part of going back to what I talked about yesterday, and we'll have more discussion of that in our one-on-ones and in our next meeting. There is a process. You'll have to, if you are not able to make it to a meeting, or not, in advance you're not going to be able to make it, for example, and you let us know, we will need to arrange for a location for you to call in from. And that location will have to be known well enough in advance to be included in the agenda that is circulated to the public. And you will have to sort of take the call to participate in the meeting from a location that's open to the public and accessible. And we'll clarify that more, but this is more of where does the task force as a whole want to plan to meet in person.
Thank you for that clarification. Sorry, I kind of mixed two different conversations in one. So I understand. So now I guess the discussion is whether we want to meet at one singular place as Attorney Newman said, particularly in Sacramento, for example, or do we want to have the locations be in different places, like in a rotating basis? So I guess that's the discussion we're having right now. And I guess I'll just, to move the conversation along, if I would have to choose, I think it would be good to have locations be rotated out. So we have a hearing in Sacramento, we have a hearing in Central California, we have a hearing in San Diego, LA. I think that would be great for the benefit of the public.
I would agree with that as well. I think if you want the greatest community outreach and participation, I think those meetings do need to rotate.
And I concur. Mr. Bradford and I probably serve on several committees where they deliberately make sure they go northern, southern, and central California so that we get the most exposure. But most important, give everyone in California opportunity as best they can to come to meet with us on important issues in person. And so that's why we try to be in as many places as physically and humanly possible.
So would anyone, oh, sorry, Member Holder, you're recognized.
Yeah, I don't want to drill down yet or get in the weeds. But the other thing is, because of some of the testimony we're receiving about certain locations, we've heard testimony about Sugar Hill, Allensworth, certain locations across the state that have historical significance. I think we should think about proximity, our meetings' proximity to some of those locations, and tie our meetings to those historically significant geography. But that's a longer conversation.
Madam Chair, I support rotation and proportionality.
I agree. So would anyone like to entertain a motion around this this issue?
I move that we would rotate the meetings and make it proportional.
Is there a second?
I couldn't hear the last part. I heard the rotating, but what was the last part?
Proportional in terms of location.
North, south, central, I think he means.
Okay.
Yes.
Second.
So it has been properly moved and seconded that once we begin to meet in person, we will rotate the locations throughout the state of California and ensure that those locations are proportional. Is there any discussion on this matter?
Call for the question.
The question has been called. Parliamentarian Johnson, you can establish a roll call vote, please. Thank you.
Okay. If the question has been called, so I need to first vote a vote on ending debate, and then after that, I will go to the motion, the main motion. Chair
Great.
Moore. Pardon me?
Aye. Aye. Thank you.
Vice Chair Brown.
Aye.
Member Bradford.
Aye.
Member Grills.
Aye.
Member Holder.
Aye.
Member Jones Sawyer.
Aye.
Member Scott Lewis.
Aye.
Member Tamaki. Member Montgomery Stepp.
Aye.
Madam Chair, there were 9 votes cast, 9 ayes and 0 nays on the question.
Thank you. There were 9 ayes, 0 nays. The question has been called. Parliamentarian Johnson, may please cue a roll call vote for the motion on the floor. Thank you.
Thank you. Chair Moore.
Aye.
Vice Chair Brown.
Aye.
Member Bradford.
Aye.
Member Grills.
Aye.
Member Holder.
Aye.
Member Jones Sawyer,
Aye.
Member Scott Lewis,
Aye.
Member Tamaki,
Aye.
Member Montgomery Stepp.
Aye.
Madam Chair, there were 9 votes cast, 9 ayes and 0 nays.
Thank you. There are 9 ayes and 0 ayes, so the ayes have it and the motion carries. So we're still on the same agenda item. Just wanted to make sure we got some action through early on in this discussion. What time? 3:22. Okay, so Attorney Newman, I'm going back to you, excuse me, for a review on what is left for this part of the agenda, what is still unresolved.
Sure. So based on the vote to have a rotating basis, the next question is where to have the meetings. And the task force can either right now pick, and it's totally up to you. You could pick 5 cities and do 2 meetings in each city, or you could have 10 different cities. You can have that discussion now, obviously, or you can delegate that to somebody. Chair Moore, you gave the presentation in the first meeting about the different meeting topics. You could delegate to somebody to come up with meeting topics and locations that responds to member holders' comment about certain meeting topics or certain discussions, also including on their agenda issues that are pertinent to those areas. So maybe a geographic aspect. If we have a meeting in San Diego, we have testimony about specific San Diego historical issues, things of that nature. And that's something that you can either do here as a group in discussion, or you can delegate to an advisory committee to return at the next meeting with a proposal for an agenda, essentially for the remainder of the task force meetings, the remaining 10 in-person meetings from February on.
Yeah, absolutely. Thank you. That was actually going to be a suggestion for me, that an advisory committee is formed to start to rethink how these future meetings should be restructured, if at all, and the component around where should the locations be for these particular meetings. I can volunteer for that. I was also thinking if member Scott Lewis or member Monica Montgomery Stepp would be interested. I think maybe since I did the presentation, I should probably be a part of the committee just so I can impart my thoughts. But if either member Scott Lewis, I don't know if you were interested in being part of this committee, that would be good. Or
Yes.
yeah, okay,
Yeah.
great. Okay, cool. And so that, I guess that's, can I give a motion? I'm the chair, but I just wanted to okay, great. So I move that an advisory committee is formed that will consist between myself and member Scott Lewis, where we will look ahead and look towards restructuring the public hearing proposal, and then also presenting to the task force ideas for locations for those meetings. Okay, so that's the motion. Second.
Second.
So it has been properly moved and seconded that an advisory committee will be established that will consist between me and member Scott Lewis, and we will work on giving a presentation at the next January meeting about location ideas for the next for the remainder of the hearings, and the substantive content of those hearings. Is there any discussion on this matter? Hearing no further discussion, I will cue Parliamentarian Johnson so that a roll call vote may be established. Thank you.
Thank you. I will call the roll. Chair Moore,
Aye.
Vice Chair Brown,
Aye.
Member Bradford,
Aye.
Member Grills,
Aye.
Member Holder,
Aye.
Member Jones Sawyer, Member Jones Sawyer.
Aye.
Thank you. Member Scott Lewis,
Aye.
Member Tamaki,
Aye.
Member Member Montgomery Stepp.
Aye.
Thank you, Madam Chair. There were no nays. I'm sorry, there were 9 votes cast and no nays. All votes were yes.
Thank you, Parliamentarian Johnson. There were 9 ayes and 0 nays, so the ayes have it, and the motion carries. So I believe that wraps up this particular agenda item. Were there any lingering comments or questions or concerns, Attorney Newman, around this particular item?
I just realized that the advisory committee will be coming back in the next meeting with the proposed locations, which the task force will have to vote on, which means we will not necessarily have a vote. We will not have a location for the February meeting in order to gauge people's ability to be at the February meeting. So the one last thing I would suggest, I know this is kind of backtracks from the last motion, but maybe if for the ability for the task force to all plan for a 2-day in-person meeting in February, maybe just one thing that the task force can do is vote on a location so we can include at least that location in a doodle poll for the setting of the next meeting.
Okay. So does any member of the task force want to put out a motion and choose a location for our February meeting?
No, but I don't want to do that, but I do want us to be informed by the fact that February is Black History Month. So we may want to think about that and publicity around it and a location with easy access to media and all that stuff.
Well, maybe Oakland or something, since it's Black History Month. It has a lot of Black history there. It's an idea.
Molly and I are saying, yeah.
Sounds good.
Nothing wrong with San Francisco.
Same for Los Angeles, San Diego.
You don't have to travel. Yeah.
Oh, Vice Chair Brown, were you saying something?
Why not San Francisco?
Why not?
You said Black History Month? Maybe that's the place we go to Allendale. No, Allensworth. I'm sorry, Allensworth.
I had thought about that. It's just not easy access, but I was thinking about that. Yeah.
Tulare, is that the closest?
Yeah.
Tulare?
It's Tulare, yeah. And probably Fresno would probably be your closest airport, and then drive in from there.
Well, I yield to Allensworth because of his historicity.
I would strongly support an Allensworth meeting. I just don't know if February
Right,
might be
the
the best
access.
time for it.
Right. Oh.
I don't know. I'm checking the chat. People are saying Fresno, El Centro, Leimert Park, California African American Museum, Central Valley. I'm down to go anywhere, to be quite honest. So, if anyone wants to, if we want to just put a motion on the floor and then we can discuss, we can do that. Attorney Newman, you're suggesting that this be done now, right?
Yeah, well, I'm suggesting that we set the meeting at least for February so that we can circulate the doodle poll, and in the materials for the January meeting, include the dates for the February meeting and the location for the February meeting for public notice purposes.
And Dr. Grills, do you think the communications team will be sort of up and running in time to really advertise a February meeting? If it was, let's say, if it was in a place that was a little bit more remote, like Tulare, to get the media out there and to get the public out there, you know?
Yeah, with it being a little bit more remote, they would be wanting to do probably more research to figure out what are the best avenues for communication to reach, not the easy to reach, but the harder to reach folks who are kind of off the grid of typical media platforms. So it's possible, but I really couldn't speak for them. I think remote makes it perhaps a little more challenging.
So let's go back to the California African American Museum, which has parking. It is a state facility. You don't have to worry about access or even trying to get it scheduled or putting on the agenda. And it's only about 100 feet from my office.
I was going to add that he could walk.
It has African American in it, so.
I would agree with Mr. Jones Sawyer. I think LA might not be a bad place to kick this off. You'll have greater media access with maybe the best possibilities of getting great coverage. And LA, for the most part, is easily accessible. And then we could venture out in other parts of the state after that once we roll this first meeting out.
Member Tamaki, excuse me, you're recognized.
Okay. I agree with that proposal. And I think Allensworth, when we think about it, has the potential for maybe even a bigger media splash if it's planned. I mean, the Central Valley is hard to get to. And I don't know if it's changed recently, but even flights into Fresno, it's easier to drive there if you're in Northern or Southern California. But if there's an opportunity, even for, this is outside the meeting, but for task force members to visit Allensworth and then provide, I don't know what's there, but even if it's a ghost town, to provide some visuals and maybe a historian, and then line up the television cameras. I think it's a great story, and it sort of encapsulates, one of our major purposes in a very stark way. But I think it has to be planned, and the media needs to be prepped, and so they can plan. So I think it has the potential really to be a high potential event for public to be informed. So I love that idea, but I think for the February meeting, LA makes a lot of sense.
So would anyone like to entertain a motion at this time?
I will make a motion that our first in public meeting of the Reparations Task Force for February would be conducted in LA, and specifically at the African American Museum located in Exposition Park.
Madam Chair.
Yes. Vice Chair Brown?
Before we take that motion, I would like strongly to suggest that we need to have a significant presence here in Northern California, and specifically San Francisco, because in terms of the presence and protests against this evil of injustice and racism, the epicenter of the last 50 years or so was here in San Francisco. W.B. Du Bois celebrated his 90th birthday here before he went to meet Chairman Mao and ultimately settled in Ghana. When Paul Robeson first came back to the United States, after this nation had messed over him because he stood up for justice and telling the truth about enslavement, his appearance was at Third Baptist Church, 1957, July the 26th, when no one else would even speak to him. And then, first black pastor of the oldest predominantly Black Baptist church in the Western United States, Charles Satchel, who's the great-grandfather of Shirley Graham, the wife of W.B. Du Bois. See, in San Francisco. And then the Harlem of the West, our culture, our entertainment, was the Fillmore. Not Southern California, but the Fillmore, where there was a thriving business community that was displaced by so-called redevelopment, but it was black removal. I think we need to flex our muscles and make some noise here in Northern California, in addition to venues in Southern California.
Oh,
And then
I will.
Willie Lewis Brown Jr. was the first black mayor of San Francisco and had the longest tenure as Speaker of that assembly.
I'll respectfully withdraw my motion.
Okay, thank you. The motion, does there need to be do we need to vote to withdraw the motion, or it's just withdrawn because there was no second, right? Okay.
Correct.
Thank you very much. Okay, so the motion has been withdrawn. So now there's space to make a new motion. So would anyone like to entertain a new motion as regards to what will be our first location for our first in-person hearing in February?
I make a motion that we make it San Francisco.
Is there a second?
I will second that motion.
So it has been properly moved and seconded that our first in-person hearing will occur in San Francisco in February. So now we'll have discussion on this matter. So I have a question to Vice Chair Brown. Is there a particular location in mind that you have in mind for the city of San Francisco?
No, we can arrange that. Yeah, we take care of that.
Okay, great.
I was just curious.
And I don't care whether it's San Francisco, LA, Central, or whatever, just that we meet somewhere. I just want to go on the record that Los Angeles's record is just as esteemed as San Francisco. Central Avenue, the Watts riots, the 92 riots. Martin Luther King was met at the airport by Kenny Hahn when nobody else would meet him there. So we too, Watts has a rich history of culture. So we too have that. Just want to make sure I put on the record that we are just as distinguished in African American culture as San
All
Francisco.
right. I say amen to that.
I would agree. And part of the miseducation is that people don't even know the term South Central LA was derived because African Americans were moved from downtown Los Angeles in the 30s and moved to Central Avenue. And that was the hub. And you had the Dunbar Hotel, Club Alabama, Club Flame, where Duke Ellington, Ella Fitzgerald, they all played and resided there on Central Avenue. So I agree with Mr. Jones-Sawyer. There is a rich history there.
Also means, wherever we have the location, again, I'm turning to the communications firm. It would be good to build the publicity and the outreach around the locale. I think it's a great local story, for one thing, if you're in the media, to highlight the history and the meaningfulness of the task force meeting in that particular locale. So I think the same principles apply to every location, if we could do that.
Well, now we have our second one down in Los Angeles. I'd like to make that motion, that the second one be in Los Angeles.
We still have to get through the first motion, and just to be clear. So there was a second, right? Member Bradford, you seconded?
Yes, I did.
Okay.
That might be an addendum to his motion, but yes, I did.
Okay. So we're still in the discussion phase. Are there any comments, questions, concerns related to the idea of having our first meeting our first in-person meeting in San Francisco in February?
I would just like to suggest, if time permits, regardless of what the locations are, that we maybe get a 15-passenger van and do a historical visits of many of those sites. I think that's media traction as well. So I think to show the importance of those locations and locales, and and what's there today too. So
well, I have two vans for you.
Okay. All right. Are you driving?
No, I have a chauffeur for you.
So is there any other discussion on this matter?
Should I throw Oakland in the mix just to?
We'll include them too.
All right. So hearing no further discussion, I'll take it to Parliamentarian Johnson so that a roll call vote will be established. And again, the motion on the floor is that we will have our first in-person hearing in San Francisco in February.
Thank you, Madam Chair. Madam Chair?
Aye.
Vice Chair Brown?
Aye.
Member Bradford?
Aye.
Member Grills?
Aye.
Member Holder?
Aye.
Member Jones Sawyer?
Aye.
Member Scott Lewis?
Aye.
Member Tamaki?
Aye.
Member Montgomery Stepp?
Aye.
Madam Chair, there were 9 votes cast, 9 ayes and 0 nays.
Thank you. Excuse me. There were 9 ayes and 0 nays. The motion carries. So we will have our first in-person hearing in February, and the location will be San Francisco. Thank you, Vice Chair Brown.
Madam Chair,
yes, you are
would it be in
recognized.
order for me to make a motion for the second meeting?
We do that.
Would it?
Yeah, I'm sure we can.
No, I move that we go to Los Angeles for the second meeting.
Is there a second?
Second.
Okay, it has been properly moved and seconded that our second in-person hearing will occur in Los Angeles. Is there any discussion on this matter? I guess the discussion I would say is that, I don't know if we can amend the motion to say we'll, look into using the California African American Museum for that location. Yeah. Are there any other comments, questions, concerns, discussion on this motion? Hearing no further discussion, I'll turn to Parliamentarian Johnson so that a roll call vote will be established. And again, the motion on the floor is that second in-person hearing will occur in Los Angeles.
Thank you, Madam Chair. Chair Moore.
Aye. Aye.
Vice Chair Brown.
Aye.
Member Bradford.
Aye.
Member Grills.
Aye.
Member Holder.
Aye.
Member Jones Sawyer.
Aye.
Member Scott Lewis.
Aye.
Member Tamaki.
Aye.
Member Montgomery Stepp.
Aye.
Madam Chair, there were 9 votes cast, 9 yeas, and 0 nays.
Thank you. There were 9 ayes and 0 nays. The ayes had it, so the motion carries. Okay, so we will move on to the next agenda item, which is agenda for next hearing, review, discussion, and possible action item. And I will again turn to Attorney Newman for assistance on this agenda item. Thank you.
Sure, no problem. And just to finalize, so we will take those locations that you provided and we'll do a doodle poll for everybody for the February and March meetings based on those 2 locations. So we do ask that everyone respond to that doodle poll so that we can coordinate. And keep in mind, and again, one of the issues I think Chair Moore that needs to be addressed in this meeting is the information that we obtained from the doodle poll was that January 27th and 28th is what worked for a quorum. We did not get a full response. So I don't know if you had wanted to raise the question of whether the 28th and 29th should be considered by the task force. As a reminder, this will be a virtual meeting. So I don't know if you want to take that question first or if you want to walk through the agenda first.
We can take the question first. Can you restate the question, please?
The question is, we didn't get a full response on the doodle poll with regard to potential meeting on Friday the 28th and Saturday the 29th. And felt that it was, given the discussion that was had during the last meeting, merited discussion as to whether the non-full response on the doodle poll indicated that people truly were not available on those dates, or if you wanted to have a discussion with the members of the task force in the meeting about reconsidering those dates or confirming those 2 dates, the 27th and 28th as in the agenda that was included. Oh, you're muted. I can't hear you.
Chair, you're muted.
Oh, sorry. How about we look at the proposed agenda? Maybe that will inform the discussion a bit.
Okay. So based on the discussion in the last meeting in which the task force directed the Department of Justice to create a new meeting in January that focused on all aspects of health, which include public health, mental health, and physical health, as well as shifting technology from the busy agenda we've had these last 2 days to this other meeting in January. We devised a proposed agenda that would encompass these topics. You can see them now on your screen. Trini, if you can go to the next page, there you go. So in the agenda as proposed, the first day would include a morning panel on discrimination and technology and an afternoon panel on public health. The second day would include a morning panel on mental health and an afternoon panel on physical health. The additional items that we've included on the draft agenda are an additional discussion on community of reparations, in which we would seek to invite Secretary of State Shirley Weber, based on the vote the task force took in the last meeting, and potentially additional legal and other experts on the issue of reparations, including lawfulness and things like that, that have been the subject of discussions.
I guess so. My question was going to be, if this upcoming meeting in January had to be 2 days, but now that I see, the agenda, it seems like it might have to be, but maybe it doesn't. I'm wondering if there's a way to reconfigure the agenda so that it's just one day, so that that adheres to what people have already said they're available for, that one particular day, right?
I'm sorry, just to clarify, according to the doodle poll, we have a quorum on both January 27th and January 28th, handling the meeting virtually. It still will be virtual. The question that was pending was, we did not get responses that indicated a quorum on Saturday the 29th. And so that was really, the question is, did the task force want to address whether there would be availability on the 29th and schedule the meeting for January 28th and 29th instead? And again, the reason we're asking this is because we didn't get full responses on the doodle poll, and also since we're appearing virtually, in case people wanted to reconsider their availability.
Okay, thank you for that clarification. I'm of the opinion we should just stick to the dates that people have where there's a quorum, which is Thursday and Friday. But if other task force members would like to speak on the idea of being available on that Saturday, please feel free to do so.
I agree with you. I agree. If we've already done the legwork to figure out those days, let's stick to those days. We can do it on a Saturday another time. And it definitely seems like this needs to be a 2-day meeting.
Mm-hmm. I agree. So I guess I'll put a motion on the floor just to get things moving, that our next hearing will be on the 27th and the 28th, which are the dates that a quorum has already been established. And so by virtue of that, it will be a 2-day virtual hearing. Does that motion satisfy the concerns, Attorney Newman?
Yes, it does.
Okay.
Chair Moore, I'll second.
Okay, thank you, Member Montgomery Stepp. So it has been properly moved and seconded that our next hearing in January, which will cover all aspects of health and technology, will be a 2-day meeting on 27th and 28th, which is a Thursday and a Friday. That is a motion. Is there any discussion on the motion? Hearing no discussion, I will turn to Parliamentarian Johnson so that a roll call vote will be established. Parliamentarian Johnson?
I'm trying to check and see if there's a technical issue. I think we've had a technical.
Hello, Chair Moore. I would be happy to take the roll.
Thank you, Ms. Martin Walton.
Yes.
Stacy, thank you.
Okay, I will go in order, and this is to the motion to accept the January 27th and 28th as the next meeting. It will be remote. And I will go in order. Chairperson Moore.
There's feedback, but aye.
Oh dear, I wonder why.
Aye.
Chairperson.
There's some feedback. I don't know if everyone can mute who's not talking until you need to vote on the motion.
Okay. Oh, that's better. Member Bradford?
Aye.
Member Grills?
Aye.
Member Holder?
Aye.
Member Scott Lewis? Member Scott Lewis? I think you are muted. That's Scott Lewis. I think so.
Did you get aye for Vice Chair Brown?
Member Tamaki?
Aye.
Member Jones Sawyer?
Aye.
And Member Montgomery Stepp?
Aye.
Madam Chair, there are 9 members present and voting, and the motion passes unanimously.
Thank you very much, Ms. Martin Walton. Given that the motion carries, we will move on to the next item on our agenda, which is unfinished business. And so I'll turn to Attorney Newman for that, where we're going to have a conversation about whether or not we are going to approve Dr. Derek Hamilton's narrowed or renewed scope of work. So Attorney Newman, the floor is yours.
Sure. Thank you very much. I think we're going to stop sharing the agenda just so everyone pops back into there it is. Okay. So this is just a follow on to yesterday's unfinished business from yesterday's discussion. You all heard from Dr. Hamilton about the scope of work, and the task force has to make a determination whether to authorize the Department of Justice to enter into an agreement contract with Dr. Hamilton based on this narrowed scope of work, as well as whether to direct the Department of Justice to find another expert or experts to come up with the calculation for reparations as set forth in the statute. So those are the 2 remaining items of unfinished business.
Attorney Newman, can you repeat the second item of unfinished business? Sorry.
Sure, no problem. So under AB 3121, the task force is required to determine how, in consideration of the task force's findings, any form of compensation to African Americans with a special consideration for African Americans who are descendants of persons enslaved in the United States is calculated. Pursuant to our conversation yesterday, Dr. Hamilton indicated that he was able to do the second component, which is how, in consideration of the task force's findings, any other forms of rehabilitation or restitution to African descendants are warranted, and what form and scope those measures should take, as well as what form of compensation should be awarded through what instrumentalities and who should be eligible. I think I misstated that, but it's subsection F of subdivision 2 of 8301.1 in AB 3121. So essentially, task force originally directed Dr. Hamilton and planned for Dr. Hamilton to handle both the cost and manner of reparations. Based on the narrowed scope, he has agreed to handle the manner of reparations, and the task force still has to determine how to calculate cost. Was that clear? I didn't know if you have any questions.
Sorry. Yes, it's all related to Dr. Derek Hamilton. I guess that's just the clarification that I wanted to get.
That's right.
So, yes. So, yes, just as Attorney Newman said, so if you all recall I believe it was a September meeting, not the October meeting, it was a September meeting where the research office, Department of Justice Research Office, gave a presentation essentially asking us to approve Dr. Derek Hamilton as our economic consultant. And as Attorney Newman said, and this is in the presentation materials that the research office gave us, that Derek Hamilton would agree to do what's in the bill, subsection E and F. So, when we approved Dr. Derek Hamilton being our economic consultant and going through the contracting process, it was under the assumption, right, that he would, as Attorney Newman said, in consideration of our findings, help to actually calculate any form of compensation to African Americans, with a special consideration for African Americans who are descendants of persons enslaved in the United States. And then he would also, in addition to those calculations, help to form what methodologies or instrumentalities through which that compensation should be awarded. So that was what was presented in the September hearing. But fast forward to yesterday, Dr. Derek Hamilton essentially, communicated to the task force that while he's still able to deliver on subsection F, which is, coming up with methodologies or instrumentalities for which any compensation should be awarded, he essentially said that he will no longer be able to deliver on subsection E, which is doing the actual calculations for what any compensation should be. And he named that, there weren't enough resources presently in the given contract, that he felt that he didn't have enough time. And then he also pointed out issues of clarity where he was unclear as to kind of how to tackle that part of the bill. And so now we're here where now we have to have a conversation about whether we continue to work with Dr. Derek Hamilton so that he can fulfill subsection F, which is figuring out those methodologies and instrumentalities that I brought up. But then that begs the question of, if we continue with Dr. Derek Hamilton, he does subsection F, who is going to do subsection E, which is the actual calculations. And from my understanding, if we do continue to work with Dr. Derek Hamilton for subsection F, the contract would have to be reduced from, $90K to $45K, because he's not going to be able to deliver on subsection E and F. He can only deliver on one subsection. So that is where we are right now. Are there any comments, concerns, or questions, clarifying questions about where we are and how we should continue? Member Tamaki, you're recognized.
So this is an inexpert, ignorant kind of question, but are the two concepts separable? In other words, my common sense thinking is you really can't calculate costs without having an agreement on methodology and instrumentalities. Because one follows the other. It sounds logical. And if we had two people, basically they would really have to work with each other. And there might be some disagreement. For instance, somebody who is calculating the cost might say, well, I don't understand the methodology. How did you do that? How does that make sense? And I'm just wondering if there are any inefficiencies in that. And then I'm not saying we change everything up right now, but I'd like to know how much work he's been done already. And in other words, if he's done a lot of work, maybe it doesn't make sense to get somebody brand new in there. But the synchronization seems to me would have to be doable. But if he hasn't done any work, the good thing is we know early in the process before we, have to tackle the remedies end of it. Maybe it makes more sense to have one person who devises the methodology and the instrumentalities, but then also has a sense of, okay, how do you calculate cost on this? It just sounds like there's trying to separate what might be inseparable. So I pose that.
I had the same concerns. I fear that the work isn't severable. But Attorney Newby, can you answer the question as to whether Dr. Derek Hamilton has done any work so far in this?
Sure. I think Tiffany Jantz from our office may be on. I would like to give her a chance if she can be promoted into being a speaker. But we have not, to my knowledge, he has not done any reimbursable work under the contract. The contract hasn't been signed or anything like that. We've been going through the process of determining the scope of the agreement, which is what came before you yesterday. And so to my knowledge, other than sort of scoping out the project and doing initial evaluation and preparing for his appearance and testimony yesterday, he hasn't done anything on the project. So I don't know if the task force did not proceed with him, whether he has thus far. I think he's incurred probably reimbursable time in his initial preparations, and we have to talk about that with him. But he hasn't, to my knowledge, or I don't believe he's actually performed any aspects of the contract. And I've successfully delayed long enough to allow Tiffany to try to get on here. Tiffany, I don't know if you heard all that. Do you have anything, Tiffany Jantz DeSormo from our research center? Do you have anything that you can add to that or clarify?
I will just confirm what you stated, that while we have sent a letter of retention so we could acquire a scope of work to be presented before the task force, there has not been a contract signed, and there has not been work done outside of the scope of work draft that he presented yesterday, to our knowledge.
Thank you. Are there any other questions, comments, concerns related to this? I will say that we do have William Darity and Kristen Mullen. William Darity is an economist at Duke, and at our first meeting, at our July meeting rather, we ratified Darity and Mullen's work with the DOJ. And so Darity is consulting the task force already, and he's also an economist. And so, that is an option that we can look to him, for the calculations and potentially for the methodologies if he can recruit other economists in his network, like Trayvon Logan, for instance.
In the book From Here to Equality, he has a number, and it's anywhere from 9 to 14 trillion. But it's 2 or 3 pages at the end of the book, basically. So we don't know the methodology or what he was considering, but in order to get to a number, I presume that he did it's based on something. And so that's one concern, whether it's more efficient to have one person do this. And the other piece of it is the report is going to get a shot at. it's going to be highly scrutinized and criticized and really taken apart. So this part really has to be, it seems to me, a first-rate expert in this area. I mean, Darity has stature for sure. So that would be consideration, but beyond that, I'm pretty ignorant. Maybe Siobhan Scott Lewis that knows Hamilton and knows Darity and could comment. But I'm just worried about breaking it up. If you split it in half, for all we know, the calculation part might be more time and cost than the other part, and there's not enough money on the back end. So that would be another consideration. It's not as if the thing could be neatly severed, divided 50-50. It may not be. So I just throw that out.
And I'm of agreement with Mr. Tamaki. The bifurcate this work, I think, is the wrong road to go down. I think it does need to be done by either one person or under one roof for sure, because there needs to be great coordination and moving forward on that.
Member Groves, you're recognized.
I just was wondering, this is for attorney. Did we have any information how much additional cost it would be to delete?
Sorry, there was a lot of feedback. I think you were asking me about the cost.
Yeah, did he indicate what the additional cost would be to actually compute and do the calculation?
No, we were not able to get an additional cost or how much additional time.
I'm also proposing that this could also be potentially an advisory committee, where members of the task force, address ENF, where the advisory committee could take the lead on like working through the contract with any of the economists that we might choose, and working on the second report in particular, where those calculations will be in. Just an idea as well. But are there any? Oh yeah, Member Scott Lewis.
Thank you. Those are lucky. The book still right of catastrophe. Which one did see?
Sounds like a robot. What?
I don't know.
Or am I missing something?
Unintelligible. Go on.
Maybe, I don't know, Member Scott Lewis, yeah, if he can log back out and log in again. Sorry. We've been trying to figure out behind the scenes the technical aspects.
If he's unsuccessful, he can also type his comments in the chat.
I mean, in this realm of experts, what I'm concerned about is we get somebody connected to the academic community, and then person's familiar with research of this kind. So I think, yeah, that's why I was thinking we turn to Javon on this.
I'm back. Can you hear me now?
Yeah.
Yeah. Okay.
Yes.
I had to log out, log back in. That classic move. No, I just wanted to say that, Member Tamaki earlier mentioned Sanidarity's book, and in the book he draws on several economists who have various models. So in other words, he's coming to his conclusion not just by his own calculation, but by thinking through several other calculations. And I just wanted to bring up that one of the one of the models that he relies on is actually presented or provided by Thomas Kramer, who we had as a witness a couple of meetings ago. So it might be worthwhile to maybe reach out to Kramer and Darity to think about the scope of what kinds of models might be out there and what the community of economists might be that will be reliable. But I agree that I think we shouldn't bifurcate this duty. They are related, and so given Dr. Hamilton's limitations, I believe that we should be looking for a new economist or a team of economists actually who might be willing to do these calculations for us.
Member Groves, you're recognized.
Yeah, I agree with Member Scott Lewis. I would just caution us from characterizing his statements about this as his limitations. I think he's trying to share with us some cautions about really what it takes to do a careful and set of calculations that are aligned with how we are defining some of the factors that would go into an understanding about costs. So I wouldn't call it a limitation. I would call it, perhaps he's offering some caution to us about exactly what it does take to do this and to do it well, and to do it in a way that minimizes some of the negative feedback that we're going to get on everything we do. I mean, we should just anticipate that even how we dot an I and end a sentence with a period will get critiqued.
Duly noted. Thank you, Member Grills. Are there any other questions or comments or concerns? If not, we can entertain a motion. And entertain a motion and put two things into one motion. So I move that the task force not elect to proceed with Dr. Derek Hamilton's contract. And in the alternative, we communicate and contact Dr. Darity to see his availability and interest in convening a team of economists to tackle subsection E and F in AB 3121 bill text. So that's the motion on the floor. Okay, great. So it's been properly moved and seconded that the task force will not proceed with Dr. Derek Hamilton's contract for the economic consultant position, and instead we will follow up with Dr. Darity to have conversations around him assisting along with a team of economists that he's connected to fulfill subsection E and F of AB 3121 in the bill text. Is there any discussion on this matter? Okay, hearing no further discussion, I'll turn to Parliamentarian Johnson so that a roll call vote may be established.
Thank you. Chair Moore?
Aye.
Chair Moore votes aye. Vice Chair Brown?
Aye.
Vice Chair Brown votes aye. Member Bradford?
Aye.
Member Bradford votes aye. Member Grills?
Abstain.
Member Grills abstains. Member Jones Sawyer?
Aye.
Member Jones Sawyer votes aye. Member Holder?
Abstain.
Member Holder abstains. Member Scott Lewis.
Aye.
Member Scott Lewis votes aye. Member Tamaki.
Aye.
Member Tamaki votes aye. Member Montgomery Stepp.
Aye.
Member Montgomery Stepp votes aye. Madam Chair, there were 9 members present and voting. There were 7 ayes and 2 abstentions. No nays.
Thank you, Parliamentarian Johnson. There were 7 ayes and 2 abstentions and 0 nays. Therefore, the ayes have it and the motion carries. Okay, so now, before we go to our last item of the agenda, I wanted to raise something that was brought up in public comment, and then I got a note from staff that this could potentially be a part of an agenda item for next month for consideration, and that is whether the task force wants to create a letter or some sort to President Biden to create a federal commission for reparations through executive order.
Madam Chair, that item, that is not unfinished business. That is an item that you need to agendize for the next meeting.
Oh, sorry. I guess I read the text wrong. I thought the staff members suggested that could be addressed in that section. Okay, so that means there isn't any space to discuss that then, because we don't have. We moved on from that already.
Right. You actually, it would have been included when you were setting the agenda initially. So if you want to go back to that, but it's not unfinished business because it was never on the agenda. But the agenda itself for January was agendized, and so you can amend that. You know what you had proposed as a topic for the agenda for January.
So you're saying I can go back if I want to?
Yes, you can go back to the agendized item. Yes, which was the agenda itself for January.
That's correct.
Oh, okay. So I guess since I brought it up, I'll just go back and bring it up. You know, I'm not much to this at all, so I can just put a motion on the floor, and if it goes somewhere, great. If it doesn't, great.
Right.
So,
it sounds like you want to do is add that topic to the agenda for January, correct?
Yeah.
Okay, so that's what you want to do, is just move to amend the proposed agenda to add that topic.
You know, before you make the motion, can I just make a comment or suggestion? I think that the letter that you're talking about actually falls into a broader rubric about low-hanging fruit items that the task force can take up right now, iteratively, before we come up with our final recommendations. So maybe we should just have a discussion about that, and this letter could be included under that.
all right, that's a great suggestion. That sounds good. So I'll move to amend that. We'll add to the agenda for January a discussion about low-hanging fruit, things that the task force collectively can, act on before the end of the process. So, is there a second?
I second.
Okay, so it has been properly moved and seconded that at our January hearing, we will have a conversation about low-hanging fruit, and that discussion could include or would include the concept of the letter that I just discussed. amongst other ideas. So now we'll move to discussion. Is there any questions, comments, discussion on this agenda item?
I do have a question. When you use the term low-hanging fruit, is it clear enough that people will understand what you mean? Is it described clear enough? You want something more descriptive that will encompass everything that you're seeking to include?
Sure. Yeah, the low-hanging fruit concept is based on what we found in this in a racial equity guide that we received early on in the process through Ohio State University. So they came out with like a racial equity guide for these types of commissions that are dealing with these types of issues. And in that report, they had a whole section around low-hanging fruit. So essentially that means what are some tangible things or work products that a task force or commission of this capacity, what can we act upon before the end of the process, before the final deliverables of the reparations proposals? Is there something that we can do that's small or tangible, in the middle of the process, that we can advertise as a win by the task force? If anyone else wants to share their thought or their ideas about what low-hanging fruit could consist of, that would be great as well.
Well, easily achievable actions which fulfill the mission of the task force that can be implemented before the task force issues its final report.
Something that needs immediate attention.
Well, things that are doable that the task force can vote to do, that doesn't have to wait to the end of the process.
Thank you. That was very well said. Thank you, Member Tamaki. So is there any further discussion on this matter? Okay, if not, I'll call parliamentarians so that a roll call vote may be established.
Would you repeat the motion?
Yes, so the motion on the floor is to amend the January agenda item to include a discussion on low-hanging fruit. And that will be a discussion on short-term or deliverables that the task force can act upon before the end of this process.
Thank you.
And I just would like to clarify one thing, if I may, Chair Moore.
Yes, Attorney Newman.
Just in terms of this agenda item, is this an agenda item that you would want to have an advisory committee or a member of the task force or DOJ present something, or is it something that you want to have a discussion in the next meeting on? So the two options would be to have some kind of presentation and vote on executing, or else just a conversation on with potential execution thereafter.
Well, maybe, did someone have a suggestion? I was going, Member Tamaki, go ahead. You're recognized.
Oh, you can't speak for anybody, but I'd like to hear a conversation. I can't speak for others. But I would like to hear a conversation. Can you hear me?
Yes.
I'd like to hear everybody's thoughts, because there may be, 3 or 4 things, or there may be a dozen things. So, I'd like to have a discussion if that can be done.
And I'm not sure if it would be too much work, but is this something the staff can assist us with when we have this conversation? Maybe can pull some examples from the racial equity guide or other areas and kind of give the task force some examples of what low-hanging fruit is in other areas or in other similar commissions that could potentially inform us. I can also do that research, but Again, I don't know if that needs to be an advisory committee or, if the staff can, commit to doing that.
Yeah, we can commit to developing some background material and information for your consideration. And also, obviously, we welcome members of the task force providing materials to us also for consideration for that conversation, which we can present back in the materials.
Yeah, Ohio State had, sponsored by the law school, had a commission, Truth and Reconciliation Commission, in which they discussed this very topic, of early victories, they called it. In other words, things that were easily achievable that would be uplifting and show progress even before the final, product was produced by the commission. So I can send you, I can research that, Michael, and send you some things.
Yeah.
Chair Moore, may I say something?
Member Girls, you're recognized.
Yeah, so I also, when I was the co-executive director of the LA County Blue Ribbon Commission, we also did a similar process where we had some quote unquote low-hanging fruit that by the time we submitted our interim report, we were already beginning to change some practices and procedures within the county. So it is possible, it is doable. I would suggest that we look at the testimony we've already received to see what the low-hanging fruit is there, that we look at the draft findings for the first report to discern what might be low-hanging fruit there as well. Because they will have already articulated the issues, the landscape, the opportunities, if you will.
Okay, great. Thank you. So there's, a motion on the floor. It's been properly moved and seconded, and I think the conversation around, a staff assisting us with starting that conversation, I don't think the motion has to be amended. So, and then we're also taking into account the comments of Grills and Tamaki. So, the motion is on the floor, and so now I would like to call Parliamentarian Johnson so that a roll call vote can be established.
Thank you. Chair Moore?
Aye.
Chair Moore votes aye. Vice Chair Brown? Member Grills?
Aye.
Member Grills votes aye. Member Bradford?
Aye.
Member Bradford votes aye. Member Holder?
Aye.
Member Holder votes aye. Member Jones Sawyer?
Aye.
And Sawyer votes aye. Member Scott Lewis?
Aye.
Member Scott Lewis votes aye. Member Tamaki?
Aye.
Member Tamaki votes aye. Member Montgomery Stepp?
Aye.
Member Montgomery Stepp votes aye. Madam Chair, there were 8 members.
Brown, aye.
I'm sorry, Vice Chair Brown?
Aye.
Thank you. Vice Chair Brown votes aye. There were 9 members present and voting, 9 ayes and 0 nays.
Thank you, Parliamentarian Johnson. There were 9 ayes, 0 nays, and 0 abstentions, and so the motion carries. Thank you all. So now we're at the last item of our agenda, which is closing remarks and adjournment. I want to thank everyone, including public and staff and task force members for, these incredible 2 days and for this incredible 6 months, right? We have covered so much ground since we first impaneled in June. We've heard in total, hundreds. We received in total hundreds of public comments, phone calls, emails. We've heard from, experts in their particular fields, and just everyday people about their lived experiences. And so I'm incredibly proud of us and what we've accomplished. This is the first in the nation effort of its kind. And, we are just architecting this process as we go. And so, I want to thank everyone for having grace about this process and having grace with each other. And now I'm looking forward to the next phase of this process, particularly when we start meeting in person and building relationships with you all. And I'm sure the public is looking forward to that as well. So those are the closing remarks for me. If there aren't any other closing remarks for other members of the task force, I would like to adjourn until next year. And I hope you all have a great holiday. Oh yeah, Vice Chair Brown, you can close us out.
I want to thank everyone and commend you for the great leadership you're giving and for the sweet atmosphere that's on the waves in every meeting. And you're all just off the chart as a dream team. Let's keep it up. Let the good times roll on.
Absolutely. And I also wanted to acknowledge the press who have been engaged in this process. We have received, press from the New York Times, the Guardian, the LA Times. A lot of us have been featured in local podcasts and in local publications. And so, this is really just the beginning, and we're looking forward to building on this work. So thank you all. And without further ado, the meeting is adjourned. See you all in January.
Well, family, that's it and that's all until January. We are moving right along towards the vision for reparations, for the manifestation of reparations. If you're not in a local fight, get in a local fight immediately, if not sooner. We need all hands on deck, family. We are at George Floyd. Okay? That's where we're at as a people. It's no joke out here. And we've got to be diligent. We need everybody. So please like, share, subscribe, turn on your notifications. And let's just keep that mustard seed going. What's up, family? I don't know if y'all can hear me earlier. I'm just talking. My Bluetooth speaker is away from me. But anywho, I love y'all Black and Strong for being over here, hanging in with us for the last 2 days. I'm very grateful to you. Angela, your directives are sound. Thank you, BB, for that. I receive it, sis. Yeah, we have to, weaponize the vote and socialize the suffering, family. The only ones that suffer under the Democrats is Freedmen. If it's a red top, everybody gets in on the suffering. We can socialize the suffering. But right now, we're the only ones suffering, and we're in the fight of our lives to prevent genocide, of our lineage. And, so what I'm recommending is not a personality contest. I mean, folks want to say, not the Republicans. I say not the Democrats. What have they done for us lately? If they had done anything for us, will we be on the bottom of this Titanic as the country's anchor? No. And we, of all people, deserve to be at the very top. Our ancestors' lives paid for all the wealth that the whites and the immigrants eat from. So never forget what you are owed. Never forget the cost of what our ancestors endured, and allow them to use you in this fight. When I reflect on the ancestors and all they suffered as being treated worse than animals. To this day, they cry harder for dogs being maimed than they do freedmen. So when I reflect on that, it strengthens my resolve. Allow it to strengthen your resolve. Allow it to guide you. Allow it to guarantee your involvement, because our children and our grandkids and our great-grandkids are relying on us to make sure they are okay, to make sure that suicide is never again a choice. Okay? Our kids are dying disproportionately from suicide all over the country because of the white oppressive bullying and name calling and tactics of the administration and the students and the parents alike. And so they are looking to us, family, for direction. And we cannot drop the ball, akin to many of our boomers. Some exceptions, very few, are in this fight. But we cannot fail the millennials and the Gen Zs and the I'm Gen X, my daughter's Gen Z. We cannot fail them. We cannot fail them. Hold on 1 second. Genesis, if you don't quiet down while I'm on this live, now you know better. Sorry, guys. Oh, child, the ghetto. Anyway, like I was saying, family, it is on Gen X. Are we Gen X? Yeah, I think she's Gen Z. Yeah, we're Gen X. Gen X, the boomers have left the building. They're cooning mostly. You know, the coon Clyburns, the coon Sheila Jackson Lees. They're cooning mostly. So it is up to us in the grassroots who will go down as the nameless of this fight. It is up to us to deliver the people, to demand that Pharaoh let our people finally go. And this is the second wave of civil rights. Okay? This is it, and our kids need us to be resilient. They can't afford for us to give in, up, or out. We are at George Floyd. 9 minutes and 29 seconds to the neck, literally and theoretically. I know that there's another word, metaphorically. That's where we're at. Michael Jordan says, Happy Mother's Day all day, every day. You overstand, but that's what we warrior women do, right? We can scream on the lives of the folks that are doing the people wrong, and we can scream at our kids and get it all done. That is what we come from, family. That is in our DNA. You come from the strongest people in the world. Don't ever let someone tell you that you are, don't ever let someone convince you that you are as bottom caste as they treat you in this country. You never let them forget that our ancestors' blood and bones are in this soil, and that we are here to finish their fight. They murdered Martin Luther King Jr. because he was demanding reparations. Okay? That's why they executed him. His last 3 years, if you go back and look at his writings and his speeches, he was demanding reparations. Because you don't get to trade us into slavery, treat us less than well poop, and capitalize on all this free labor and make us the anchor. Someone's got to trade. It's time to trade places, like that movie with Eddie Murphy. It is time to trade places, family. So I want you to lean in. I don't want you to give in, up, or out. I want you to always remember the truth of who you really are. The truth, not what these white folks and immigrants would have you to believe about yourself. You are the best people on the planet. Never forget it. That is hardwired in our DNA. No other group has endured what we endured to build the wealthiest country in the world. None. And they eat from the wealth that our ancestors built with their very lives. Yeah. Trading places. That's what's up. It's time to trade places because capitalism requires a bottom caste. We done held this L for 400 years. We're done. We're done. So with that being said, family, the light of God surrounds us. The love of God enfolds us. The power of God protects us. And the presence of God watches over us. Wherever Freedmen and its allies are, God truly is, because guess what, family? You are the face of God. Yes, you are. You're the voice of God. You're the body temple of the Spirit of the living God. Until next time, family, until we meet again, you go out in this world and you show them the truth of who Freedmen really are. And you make it a beautiful, God-inspired rest of your evening. I'm going to put some information out. I'll probably live stream my radio set tomorrow at 6 a.m. I got to call back to the DMV and get those particulars. So I'll be streaming that live. That's at 6 a.m. Pacific Standard Time. And, I'll try to get some information pushed out on the Facebook. But it will be streamed live. That's what I'm going to do. Stream that radio set because I get to talk about whatever I please. So they told me. We're going to see. We're going to see when we get this meeting, fam, if they telling me the TR roof. If I get to ramble and talk about whatever I want. We're going to find out, okay? But I'll see you guys at 6 a.m. tomorrow. Some of you at least. Probably the East Coast. The West Coast will still be in bed. But you know what? When the comrades say, Angela, we need you to come through, then Angela comes through. Yeah, family. I love y'all so much. I love you, Black and Strong. I thank you for spending the last 2 days with us as we fight for reparations. And remember, as California goes, family, so goes the nation. Peace and reparations, family. Oh, where's my outro? Always tripping when I'm trying to be smooth with it. Oh, one of these days, family.